It's all just this one. I think it's because I was playing with the tennis, because I don't like giving out the tennis before. I like saying no pass. Because it's easier that way. Because I know that they will be. Yeah, it's not. Okay. Well, the number of times involved, I'll introduce the petitioner's team, then the other side will introduce themselves. My name is Pongoya. I appear together with Mr. Elias Mutuma, Mr. Robert Mutembei, and Mr. Edgar Busiega. The petitioner is also present in court in person.
Thank you.
My Lord, for the respondent and interested parties, Mr. Eugene Mukele appears for the respondents.
Yes.
My Lord, my name is Kiremi. I appear with Ms. Betty there for the third interested party.
Yes.
My Lord, Mr. Benson Kwina appears for the fourth interested party.
Yes.
Mr. Boniface Mawera appears for the fifth interested party,
Yes.
together with Alex Mbaya.
Together with?
Alex Mbaya.
Yes.
And my Lord, Eric Muriuki for the sixth interested party.
Thank you. Councilor Kwina?
Good morning, my Lord.
Good morning.
My name is Eugene Lawi.
Yes.
I do appear together with Wahu Ngata for the first interested party.
First interested party. That would leave the second interested party. Anyone? Councilor Kwina?
Well, Lord, we are ready to proceed, but before we go on, I just want to give the court some indication
Yes.
about the time. We have flagged out 6 issues that we wish to highlight to court. And since we are before this court both for a process and merit review, we wanted to see if the court could allocate as time for that. I was suggesting that subject the court's concurrence, that you give the petitioner 2 hours to enable us to make that case conclusively.
Yes.
In addition to that, some of the annexures we have attached to our affidavits are videos, and we wish at some point in time to take the court through them for ease of the court's reference when it finally retires. So we'll need some time set aside just for playing of those videos and drawing the court's attention to the specific areas of concern to the videos. So that's my humble request, my Lord, that if we could get those 2 hours and 40 minutes for the submissions and the playing of the videos cumulatively, we'll be more than satisfied.
Let me hear from the respondents. Respondent, how much time?
Your Lordship, on the part of the respondent, for equality of arms, I could do the 2 hours, but I think I can take much less than that.
Interested parties, first IP?
Allowed on our part, in light of the fact that we are supporting the petition,
Yes.
we will be requesting for a period of 30 minutes.
Second IP is not represented today. Third IP?
My Lord, similarly 30 minutes for the third IP.
Fourth?
My Lord, we propose to do around 40 minutes.
Fifth?
My Lord, for the fifth interested party, 45 minutes.
And the sixth?
For the sixth interested party, my Lord, 30 minutes will do.
Councilor Kwina, rejoinder?
We can reserve 30 minutes for the rejoinder. We'll endeavor to take much less, but we can reserve 30.
Just calculate that time. That is 8 hours and 10 minutes. Surely that is too long. 8 hours and 10 minutes is too long. The purpose of highlighting is to pick a few powerful points and to impress upon the court why those points are determinative of the petition, either in favor or in opposition. Could we take much less? Councillor Ngoya, 40 minutes, is it really necessary for the videos? 40?
You know, the challenge about the video is that the video plays at its own pace. Unlike oral submissions, you can agree the video plays at its own pace, and therefore you pick the areas you want to do. What I want to suggest, might also that we make progress is this.
Yes.
As for the substantive parties, the petitioner and the respondent, they have no choice but to highlight all their issues. They have no choice.
Yes.
As for the interested parties,
Yes.
once the petitioner has made her issues, the supporting interested party can then pick which of the issues need not be emphasized because they, in their view, they have been well hammered. Same thing for the respondent. The respondent has the largest number of supporting interested parties, and I don't envisage a scenario where they can all take all that time indicated without an element of overlap. So that if we took the time indicated primarily for the substantive parties,
Yes.
then we see how to redistribute the time reserved for the interested parties. I think that will do justice to the case, because the interested parties, I don't envisage a scenario where, as a petitioner, I am going to leave out any issue for an interested party to be able to deal with it. I'll deal with all of them. And I envisage the same thing for the respondents, in which case then the supporting interested parties can figure out which of the issues need not be repeated to save the court's time. I think, speaking for myself, that if we do that, chances are in 5 hours or 5.5 hours we could have done with these proceedings.
Could we do it, those in support have 2 hours, 11:15 to 1:15. Those in opposition have 2:30 to 4:30, and then we have rejoinder 45 minutes. Would that work?
That should be able to work. We can endeavor to fit in that scheme of things. Give and take, we can endeavor to fit in that scheme of things.
Respondents IPs, does that work?
Your Lordship, kindly clarify on the time for the...
Those in support will have 2 hours, 11:15 to 1:15. Those opposed will have a combined 2 hours, 2:30 to 4:30. Then rejoinder by the petitioner alone, maximum of 45 minutes. Does that work?
My Lord, we find ourselves in a bit of a tech spot
Yes.
because the interested parties on this side,
Yes.
they have much more stake than the other interested parties. That is the 4th, 5th, and 6th interested parties, because that is the Speaker of the County Assembly, that is the County Assembly, and that is the mover of motion. And for that reason, my Lord,
Yes.
perhaps for this side we could have 2.5 hours rather than the 2 hours. I think that would do justice to this matter.
There's another way to do this, which would be for us to also then take the Monday, so that I don't reserve this for judgment today, I reserve it for judgment on Monday, and I maintain the previously fixed judgment date. Councillor Weru?
So I don't understand the instruction, my apologies.
It may not be possible then to conclude the highlighting today. I do have limited availability on Monday, because we cannot go past that. I've already fixed a judgment date. Could we then take also Monday, possibly from 2? Where you joined us?
Yes. At 2 is okay, because Monday morning I'm for the Court of Appeal in the regarding Gachagua appeal, but at 2 is okay. 2 I'm sure the Court of Appeal will have risen, so we can deal at 2 o'clock on Monday.
Your Lordship,
Yes.
Just before you turn off on that issue, the difference between what the court proposed and what we have proposed is only 30 minutes, not more than that.
Yes, I'm trying to accommodate you, Council, and that's why I will sit on Monday afternoon for their rejoinder. I was proposing to give them 45 minutes rejoinder, which would have fit in today. So I'll then give you that 45 minutes, then they will come for their rejoinder, which will be about an hour, from let's say 2:30 to 3:30 on Monday afternoon. Is that fine?
Your Lordship, if we agree to the previously suggested timelines,
Yes.
could we then finish today? If we say that we can squeeze our points to fit within the 2 hours as we had proposed.
So it's 11:15 to 1:15, 2:30 to 4:30. Rejoinder will take us to about 5:15, 5:30.
We can squeeze our points to fit within 2 hours. My Lord.
My Lord, I note that 2 of the IPs that are in support of the petitioner's case have
Yes.
not registered their presence today,
Yes.
yet we've allocated them 2 hours. So I think we can save on that, because I also note that one of them has not even filed submissions. So we only have 1 IP in support of the petitioner in that case.
2 hours should be sufficient. It's not a full hearing, it is highlighted. If you have 6 points and you take 20 minutes per point, then you should be done in the 2 hours. That would mean that I would give the petition about 1 hour 45 minutes, then the IP in support 10 minutes, and then anything to wrap up. That works?
Yes, correct. That's okay, it will work.
So, Councilor Ngoya, the floor is yours.
Thank you, my Lord. Allow me to begin by emphasizing that we are once again present here to assert the majesty of our transformative Constitution of Kenya 2010. And from an academic point of view, there are certain necessary tensions and relations between democracy as an ideal on the one hand and constitutionalism on the other hand. Democracy in its purest form is concerned with numbers, that the majority will have their way.
Yes.
Constitutionalism, on the other hand, is concerned with the purity of use of those numbers, that there must be no arbitrariness in the use of those numbers. So we are here to apply the principle of constitutionalism for the sake of a more stable democracy. To do that, the petitioner has filed the following documents. I consider it necessary to bring to your attention all of them so that the record captures them.
Yes.
We have the petition dated 21st August 2024.
Yes.
It has a supporting affidavit sworn on 21st August 2024 by the petitioner.
Yes.
Then we have a certificate of electronic evidence dated 21st August 2024.
Yes.
We then have a supplementary, sorry, just for a good record, the 3 documents I have mentioned were given physically to this court at our previous appearance.
Yes, yes, we have.
Yeah, thank you. Then we have the supplementary affidavit of the petitioner sworn on 4th September 2024. Maybe your assistant will now pick these volumes here now. They are all available down here in volumes. It is clearly marked volume 1. Then we have the amended petition dated 23rd December 2024.
Yes.
It is part of that volume 1. We have the supporting affidavit to the amended petition sworn on 23rd December 2024 as part of that volume 1. Then we have a list of annexures, just the list of annexures to that affidavit as part of that volume 1. Then we have the documents marked volumes 2 to volume 8, which are the annexures themselves to that affidavit sworn on 23rd December 2024. They are in volumes 2 to 8.
Yes.
Volume 9 is the further affidavit of the petitioner sworn on 27th January 2025.
Sworn on?
27th January 2025.
Yes.
Together with that further affidavit in volume 9 is the certificate of electronic evidence dated 27th January 2025.
Yes.
And in that volume, we also have the petitioner's written submissions dated 31st January 2025 and the supplementary submissions dated 14th February 2025.
Petitions, written submissions dated?
31st January 2025.
Yes.
And supplementary submissions dated 14th February 2025.
Yes.
We then have volume 10, which is a list and bundle of the petitioner's authorities
Yes.
dated 17th February 2025.
Yes.
And we have volume 10A, which is a further authority of the petitioner.
Yes.
The petitioner raises 6 issues in this petition.
Yes.
I will highlight the first 3 issues.
Yes.
And my learned colleague, Mr. Mutuma Elias, will highlight the second set of 3 issues.
Yes.
Allow me to start on the first issue.
Could I have the 6 issues perhaps?
I'll flag that out for you right away. So that, my lord, the 6 issues for determination are: 1, whether the impeachment of the petitioner
Yes.
was invalid
Yes.
for being in defiance of a valid court order.
Yes.
The second issue is whether the impeachment of the petitioner was invalid
Yes.
for being predicated on matters sub judice. Those who are pure Latin speakers will call it sub judice.
Yes.
The third issue is whether the impeachment of the petitioner was invalid for being conducted in contravention of the petitioner's right to fair hearing.
Yes.
The fourth issue is whether the provisions of section 33, subsection 8 of the County Governments Act
Yes.
contravene Article 50, Clause 2, Paragraph O of the Constitution of Kenya, and hence is unconstitutional.
Contravene Article
50, Clause 2, Paragraph O.
hence are unconstitutional.
Unconstitutional, yes.
Yes.
The fifth issue is whether the threshold for the impeachment of the petitioner was in fact met.
Yes.
And the sixth issue is whether the impeachment process was in compliance with the established principles of public participation under Article 10 of the Constitution.
Yes.
Allow me to start with the issue of whether the impeachment of the petitioner was in contempt or defiance of an order of court, and I'll also be submitting on the consequences of that.
Yes.
Well, my late Professor Okoto Gendo used to tell me that there can be no issue of law without an issue of fact. Let me begin by raising the factual issues. When you look at volume 1B
Yes.
of the petitioner's document,
Yes.
you will find Annex BKM2 to the supplementary affidavit
Yes.
sworn on 4th September 2024 by the petitioner.
Yes.
At page 369 of that affidavit is a letter dated 9th August 2024
Yes.
from Mutuma Gishuru and Associates Advocates
Yes.
to the Speaker of the Senate and to the Clerk of the Senate.
Yes.
On the face of that letter, you will see receiving stamps by both offices confirming receipt of that letter.
Yes.
That letter conveyed to the two offices a ruling by Lord Justice Kassan
Yes.
delivered at Meru High Court on 24th July 2024.
Yes.
At page 4 of that ruling, which is available at page 374 of the volume,
Yes.
the court ruled, and I quote, "The upshot of the above is that the impeachment process is halted pending my ruling."
Yes.
The upshot of the above is that the impeachment process is halted pending my ruling, and since this is a matter of public interest, the rulings will be delivered on Monday, the 29th of July, 2024.
Yes.
At page 376
Yes.
of that volume is an order of the court dated 29th July 2024
Yes.
deferring the ruling to the 20th of August 2024.
Deferring the ruling to?
20th August 2024.
Yes.
it is crucial to keep our eyes constantly fixed on the fact that the impeachment process had been halted pending the ruling.
Yes.
It is during the subsistence of this clear and unambiguous order
Yes.
that the County Assembly of Meru passed the impeachment motion
Yes.
against the petitioner.
Yes.
Allow me to draw the court then to the next factual matter, progressing with that.
Yes.
At volume number 5,
Yes.
of the petitioner's documents,
Yes.
the court will find annexure KM8
Yes.
to the supporting affidavit of the amended petition sworn on 23rd December 2024.
Yes.
And from page 1398,
Yes.
the court will see all the documents that were filed by the petitioner to the Senate. In fact, let me just put it this way. The entire Annex KM8 are all the documents that were filed by the petitioner before the Senate.
Yes.
Then the court will look at page 1399
Yes.
of volume 5. That is the document called Response of the Governor to the Impeachment Motion.
Yes.
At paragraph 2 of the governor's response on that page, 1399,
Yes.
the governor explicitly draws the attention of the Senate to the order of the High Court of Meru, the orders of the High Court of Meru of 24th July 2024 and 29th July 2024. The governor explicitly draws the attention of the senators.
Yes.
At page 1414 of volume 5 is the affidavit of the governor before the Senate. Page 1414 is the affidavit of the governor before the Senate.
Yes.
At paragraph 6 of that affidavit,
Just a moment. That's paragraph 6.
of that affidavit, which was sworn on 16th August 2024,
Yes.
the governor draws the attention of the Senate to the orders of the High Court at Meru of 24th July 2024 and 29th July 2024,
Yes.
and annexes those orders as exhibits.
Yes.
Then we go to volume number 1A of the governor's documents. Volume number 1A of the governor's documents, you'll come across
exhibit BMK 1D.
1D?
1D for dog.
Yes.
Exhibit BMK 1D is a Hansard, rather the Hansard of the afternoon sitting of the Senate
Yes.
of 20th August 2024. The Hansard of the afternoon sitting of the Senate of 20th August 2024.
Yes.
In that volume, that Hansard starts at page 223.
Yes.
If you go to page 343, which is a continuation of that Hansard,
Yes.
you will find a part of the submission of counsel for the governor, coincidentally yours truly, my lord.
Yes. Just a moment. Yes.
It starts, the material part for purposes of this submission, it starts at paragraph 6 of that page, which starts with the words finally. But I only want you to write verbatim these words because there are many. I'm going to read them, but I'll give you the effect of the words I'm about to read.
Yes.
For the governor, it was submitted, and I quote, that finally, Madam Temporary Speaker, sir, the impeachment process itself, in its entirety, I wish to refer you to volume 2 of the governor's document at page 28 to 32. On page 28, you can see Meru Constitutional Petition number E013 of 2024. The parties to that case are Honorable Kwina Mwangaza, the petitioner, and the County Assembly of Meru, the respondent. The two parties now appearing before you and represented by counsel, as has been the case. If we turn to page 31 of the governor's volume 2, there is a ruling of court. The ruling of the court says the upshot of the above is that the impeachment process is halted pending my ruling. Since this matter is of public interest, the ruling of the interested parties and the main petition will be delivered on 29 July 2024 via email. It is in the public domain that that ruling was not delivered on that day and is still pending delivery, and this order remains in force. As a matter of principle, I invite senators to reflect on this question because the governor has been brought here by the county assembly claiming that it wants to strike a blow for the rule of law. And yet, we are here debating this matter in the face of an order of court reading, and I quote, the upshot of the above is that the impeachment process is halted. As a matter of principle, distinguished senators, what position do you want to take on this matter? You are the judges. You will make the decision one way or the other. I have done my part as a legal representative to my clients. I have made full and candid disclosure that we may be perpetuating a violation of the rule of law. I am not the decision maker. I leave the eventual decision to your able hands, distinguished senators. Is this the way we shall grow our institutions? If a court of competent jurisdiction can make an order such as this, and the county assembly proceeds in violation of this order, the governor has told you, on her part, she has taken some action on this violation, and from page 35 onwards, you will see a contempt of court application that has been filed. She has done her part. The court will deal with that. Shall we, sitting here in good conscience and our attention having been drawn to these facts, perpetuate this process, which on the face of it, the county government has undertaken in violation of a valid court order? It is not for the governor. It is not for her counsel to make that decision. Distinguished senators, the heavier task lies with you to make a decision one way or the other on this question of principle, touching on those specific paragraphs of those specific counts that I've alluded to, and to this impeachment process as a whole, as I have drawn your attention to page 30 of volume 2 of the governor's documents. The point I'm making is this. The Senate's own document, the Hansard, confirms that the governor's counsel drew the Senate's attention to the fact that the impeachment process was proceeding in violation of an order of court.
Yes.
That is not enough, my lord. At page 353 of that volume, again,
Yes.
the last paragraph, you will see the contribution by Senator Dr. Halwani. The very last paragraph or entry on that page, 353. It says, "Thank you, Mr. Speaker, sir. I am reflecting on the history of Parliament. If Martin Shikuku, Jean-Marie Seroney, Chelagat Mutai, and J.M. Kariuki were alive, would they have wanted that the chair settles the important issue of the matters in this case that are currently active in court because they are sub judice? I will revisit the question of judice later, but one of the questions that were active before court was this petition at Meru, in respect of which a valid order of court had been issued." My lord, it is in the face of this order in Meru, it is in the face of these filings by the governor, it is in the face of these submissions of counsel for the governor, drawing the Senate's attention to the fact that it was progressing with a process in violation of the court order, that the challenged impeachment motion before you, or the challenged impeachment resolution before you, was reached.
Councilor Blair, just for clarity,
Yes.
please go back to that page 354.
Yes.
The respondents states rules that contribution was out of order.
Correct. That's part of the violation of the process, because the respondent is trying to block his attention from being drawn to relevant matters. Think about it, my lord. Think about it.
Yes.
How can it be out of order for a decision maker like you sitting here to be drawn to the fact that you are breaching the law? If any counsel here were to stand in the midst of these submissions of mine and say, "My lord, we are progressing in violation of the law," wouldn't you, in good conscience, sit down? Let us first of all assess the substance of that submission, because that is important. Rule of law is crucial. So that ruling that was out of order is a perpetuation of the determination of the respondent to proceed in violation of the existing order of court.
Proceed.
Thank you. So, my lord, we then take you to volume 10 of the petitioner's documents, and I will invite you to read in its entirety the decision running from page 109 of volume 10
Yes.
to page 118. But I would request that in reading that volume, you pay special attention to paragraphs 33 to paragraph 40 of that ruling. I wouldn't want the court again to regurgitate it, but I will read it for its full tenor from my end.
Yes.
This now is the ruling of the High Court at Meru on the contempt of court application that the petitioner before you filed.
What is its date?
The ruling is, we used to call it hot from the printing press. It's dated 13th of February 2025, barely 8 days ago.
So, Councilor I will stop your time.
Thank you.
Because we need to discuss that ruling.
Yes, ma'am.
To the limited extent, and
Yes.
I will give the respondent and any of the interested parties an ability to chip in.
Yes.
There's only one high court in Kenya. We have stations, Meru and Mwangaza.
Yes.
When you cite that,
Yes.
it's a finding of this court.
Correct.
So we cannot proceed as though I am reviewing it,
Correct.
having a merit discussion of it.
Correct.
That is your position as
That's
well?
my position.
Anyone for the respondents or interested parties who takes a contrary view? That for better or for worse, so let me explain. For better or for worse, that ruling delivered by the High Court sitting at Meru, dated 13th February 2025, is the same as a ruling of this court. I cannot revisit it. I must accept it as is.
That's the petitioner's position, is like that.
Yes. Anyone with a contrary view?
My Lord, very humbly, for the third respondent, of that interested party, sorry, I have only a challenge with your sentence that you must accept it. I think that should be qualified, my Lord, because that is a high court like yourself, and our humble view is that that decision is not binding on you. My Lord, it's only persuasive, and that is what we'll also be submitting, my Lord, that that decision is not binding on you. My Lord, perhaps also to bring to context, I am aware that there is an appeal against that ruling. The Court of Appeal has certified that matter as urgent for hearing, and I believe the appellate court will be dealing with those issues more substantively. So, my Lord, to that extent,
Has it been stayed?
sorry, my Lord,
Has it been stayed?
not yet, my Lord, but directions have been issued, certified the application as urgent. So, my Lord, to the extent that it is persuasive, we have no problem. You cannot accept it wholesome without yourself digging into the whatever I can say, the merits or demerits of that.
So you have stated, Council Kirimi, that you will also address this in your submissions.
Yes, my Lord.
Okay. So I'm not making a determination.
If I may, my Lord,
Yes.
for the fifth interested party,
Yes.
the name is Weru.
Yes.
My Lord, on the part of the Assembly, because that ruling in Meru was between the petitioner and the County Assembly, which was the respondent in that matter,
Yes.
our position is as follows, my Lord. Foremost, that ruling is not binding upon you. But even more fundamentally, my Lord,
Yes.
the petitioner has brought the question or the issue of whether there was a conservatory order stopping or halting the impeachment motion before you for determination.
Yes.
So to the extent that, my Lord, that issue is before you for determination, and parties have extensively submitted on that issue, parties have pleaded,
Yes.
we have replied, the County Assembly has replied a very detailed replying affidavit
Yes.
on the issue of whether there was a conservatory order.
Yes.
It remains a matter before you, and it is perfectly open for you, my Lord, because the petitioner brought it to court. They did not disclose that that issue was before the High Court in Meru.
Yes.
It is perfectly open for you, my Lord, to interrogate the pleadings that have been filed by parties, the submissions by the parties, and for you, my Lord, to arrive at your own independent decision as to the question of whether there was a conservatory order. It is a live matter that is before you, my Lord, and we will urge you to exercise your discretion on that question, my Lord.
When your time is reached, you will submit on that with more breath.
Thank you, my Lord.
Slogan, you may proceed.
Thank you. Just one comment so that the record doesn't capture that. Mr. Mawira says that the petitioner came here and didn't disclose to this court that there was a pending contempt of court application at Meru. The farthest an advocate can go from the truth is that submission. The farthest. Because the petitioner, in fact, attached the full contempt of court application in Meru as an annexure to the filings here. How clear can a disclosure get, my Lord? I have been at the bar for the last 20 years. I can't imagine a clearer disclosure than actually photocopying the full contempt of court application and putting it before you as one of the annexures. And more importantly for me,
No, that's not how I do things. Let counsel finish his point.
I'm guided, my Lord.
Yes. Yes, Councillor Ngwe.
Just for completeness of record, that application is to be found in volume number 9 of the documents before you at page number 64. At page number 64 onwards. Order number 2 is that the Speaker of the County Assembly of Meru, I. Bundi Solomon, the Clerk, Meru County Assembly, Jacob Kirari, and Zipporah Kinya, a nominated member, the condemned be cited for contempt of the orders of this court issued on 24th and 29th July 2024 by Justice Linus P. Kassan. It doesn't get clearer than that. Allow me to progress.
Just a moment, Councillor Ngwe. Yes, there was an interjection.
My Lord, the interjection is the issue that the petitioner did not disclose is that the question of the conservatory order was pending in another court. It's not a question of contempt. It's the issue of whether the High Court in Meru and this court, there's a possibility of these two courts arriving at conflicting decisions on the issue of conservatory order. That is the issue. It's not the issue of contempt.
Well, let me progress so that there's order.
Just a moment. Just a moment. Your time is not running.
Thank you.
So I will. This is an important link because there are certain consequences to the High Court making a finding of contempt, rather allowing a contempt application. Those facts, the factual basis that led to that decision would then be res judicata. That is the uncontrovertible position. The High Court cannot speak on the same facts, same law, same circumstances twice. That is not open to us. So what I will invite those opposed, I will add a little bit more time so that you're able to canvass that point. Because I do not want, when I retire, for myself to call you back for us to have that discussion. So we will have it extensive as to what is the application and import of that recently delivered ruling. You will appreciate, Council, that it was delivered just about a week ago, so I could not call you or ask you to comment on it or to file supplementary submissions on it. So we'll have to do that today. Councillor Ngwe, your time is back on.
Thank you, Madam. Before I progress, I noticed that when we took the quorum, the council for the second interested party was not present.
Yes.
I can see my learned colleague Eunice Lumala is present. It's only good perhaps that I put her on the record formally.
Thank you, Council.
Good afternoon, Council. How are you?
I'm fine, thank you.
It's not good afternoon. Good morning.
Yeah, and apologies for coming in late. I was before an arbitral tribunal. Thank you.
Thank you. Yes, Councillor Ngwe.
Thank you, my lord. I had already alluded to court that paragraphs 33 to paragraph 40 of that ruling, which is at pages 115 to 118 of volume number 10, are crucial. But I'll read them without asking the court to record that verbatim because the record is before the court. And this is what your brother, Justice Moreidi, observes.
Yes.
The court orders as issued on 24th July 2024 were clear, halting in any way the impeachment process against the petitioner pending the court's delivery of its substantive ruling. However, the respondents on 30th July 2024 proceeded to withdraw the previous impeachment motion and pave way for the introduction of a fresh impeachment motion. However, the orders as issued on 24th July 2024 were still in existence and had not been vacated by the court on application by either party to the suit. The respondent acted in contempt of court by seeking to reintroduce a new motion of impeachment against the applicant. It is the old lesson in Hodkinson's case, Hodkinson versus Hodkinson, volume 2, 1952, All England Law Reports at page 567, where Justices Somerville, Denning, and Roma taught yet again to obey all extant orders of court. Held by Somerville and Roma Lord Justices that it was the unqualified obligation of every person against or in respect of whom an order had been made by a court of competent jurisdiction to obey it unless and until the order was discharged. I draw my court's attention to your brothers highlighting and underlining to add emphasis to the words unqualified and the words to obey it unless and until the order was discharged. Most unfortunately, the rule of law is still under threat close to a century later. Your brother has just made a finding that the County Assembly of Meru is a threat to the rule of law almost a century after the finding of Lord Justices Somerville.
Let's circle back.
Yes, my lord.
Let's circle back. I think it is the preceding paragraph.
Yes.
A large part of the defense by the respondent and also by the County Assembly is that the initial order applied to an initial motion,
Yes.
which was then withdrawn.
Yes.
And a new motion was filed, and that led us to today.
Yes.
That finding, dated 13 February 2025,
Yes.
appears to state,
Yes.
not appears, plainly states,
Yes.
that the act
Yes.
of withdrawal
Yes.
and refiling was itself an act of contempt.
Correct. Correct. My lord.
Just a moment.
Yes.
Just a moment.
Yes.
What is the fifth interested party's position on that?
I pray that my time is paused.
Yes,
Thank you.
Yes, that's fine. Your time was paused a long time ago.
Lord, allow me to, first of all, on behalf of the sixth interested party, the mover of the two motions,
Yes.
to give a bit of context to that. My Lord, first of all, introduction and withdrawal of motions in the Assembly is guided by the standing orders.
Just a moment. Just a moment. What I cannot do is I cannot sit in review of that. That decision. It is a decision of the High Court and High Court judge. All I need us to agree upon is what is the import of it for the High Court. Can I look at a finding of contempt, because there is a finding of contempt with respect to the second motion and this one. It's just that. What is it?
My Lord, our view is that the ruling that my senior has talked about
Yes.
is with regard to the impeachment motion, the initial motion that was dated 15th and that was tabled on 17th of July.
No, that is not what the ruling. That is not what the ruling says at all. The ruling says the mere fact of withdrawing the initial motion and filing a fresh motion was itself an act of contempt. It's plainly so. You will not get another opportunity.
What is the question, my Lord?
Sorry. What is the import? Does that bind you that that second motion was in contempt of a court?
My Lord, for the fifth interested party,
Yes.
in response to your question, my Lord, the ruling of 13th, that where there's a finding that the act of withdrawal was in contempt of court. As a fifth interested party, my Lord, our position is as follows. Firstly,
Yes.
we will not be asking you, my Lord, to review that decision by the High Court in Meru.
Yes.
We are not asking you to sit on appeal of that ruling, my Lord. We are only saying that that ruling, my Lord, is not binding upon you, because this matter is before you for determination. And perhaps, my Lord, it might help that in our submissions and even in our replying affidavit,
Yes.
we contend that the petitioner has sustained two petitions, and that there are some aspects of this petition that are sub judice, the petition in Meru. Such that, my Lord, if a finding is made in Meru, the petitioner, by sustaining similar issues in these two petitions, is applying that decision here. And my Lord, she cannot benefit from that mischief. And that is why, my lord, we were saying she has come to court with unclean hands. That the High Court in Meru is seized of some matters which are equally seized with, my lord. And this matter is now before you for determination, my lord. It's either the petitioner concedes that some of these issues are sub judice,
Yes.
or the court proceeds to determine these matters altogether, because these are matters that are before you for determination. Not on review and not on appeal.
Just a
Determine
moment.
them afresh. Yes, ma'am.
Just a moment. The reason why I am sorry, there's a hand out there. I don't know whether that's
Your Lord, Zipporah
Yes.
Kenya, the mover of the motion.
yes.
And if I'm allowed, I can explain why I moved a second motion, and I can explain why I feel there were no court orders,
Yes.
if I'm allowed.
Yes, Madam Zipporah, first of all, good morning. How are you?
Good morning. Good morning.
You're represented by counsel. You were joined as an interested party separate from the assembly within which you serve. It would not be proper for me to open essentially a hearing by receiving comments from yourself. However, what you can do, you can whisper into your counsel's ear
Yes, yes.
and then stand down.
Yes, yes,
Counsel Odoya, I stopped your time for 10 minutes, so I'll just add.
My lord, you may.
Yes.
I was not done.
Oh, sorry, neither was I. I said, then I lost my train of thought.
Yes.
The reason I'm stressing this point is it is potentially determined that this entire, if indeed it has already been finding that the second motion was in contempt, and the High Court, sitting as this judge, cannot re-examine that, it would then potentially be determined in favor of one direction.
Indeed, my lord, I was not done addressing you.
Yes.
Perhaps my colleague, I'm co-appearing with Mr. Baya. You can address
Yes.
you further
Yes.
for the few interested parties.
Yes, Mr. Mbaye?
Yes, good morning, my lord. My lord, for the record, my name is Mbaya.
Yes, good morning.
Yes, this is a very critical issue before the court, my lord.
Yes.
And I will try to make it as simple as possible for the courts to be able to make a good finding on this issue.
Yes.
We are having a situation here, my lord, where we have two petitions filed before the High Court in different stations. One in Meru and one before the Lordship.
Yes.
My lord, the petition in Meru raises quite a number of issues which are before your lordship this morning.
Yes.
My lord, the petitioner goes to Meru, files a petition,
Yes.
gets orders on the issues that she raised in Meru.
Yes.
But then she comes before your lordship, she files another petition and seeks to get the same order. The only difference that she does is that the respondent in one case is the county assembly and the respondent before your lordship is the speaker. But essentially the petitions raise the same issues. She gets a ruling in Meru on one of the issues.
Yes.
And she expects to get probably a similar order before your lordship. She comes to the ruling before your lordship and she tells you that these matters that are raised before your lordship should not be considered
Yes.
by your lordship because the petition that you had filed early in Meru has already determined that issue. So you are now bound and cannot proceed. That is what the petitioners are telling you, my lord.
Yes.
It is a clear abuse of court process, my lord, because those issues which are before your lordship are some of the issues that the respondent and the interested parties have extensively submitted on. So the question before your lordship this morning is very simple. You have a petition before you which raises these very issues that you are bound to determine. But now the petition is telling you, no, don't determine them, even though you raised them before your lordship, for the simple reason that now you have a favorable ruling before from the High Court as well. And this is our contestation, my lord.
Yes.
The proper thing for you to do, the proper approach before it's honorable court,
Yes.
is to reconsider the petitioner's petition before the court on that issue and the responses filed by the respondent and the interested parties, and reach your own conclusion based on the petition that has been filed before your lordship. It is only that way, my lord, that justice in this case can be served. Alternatively, my lord,
Yes.
is for your lordship to reach a finding that the petitioner has acted with an unclean hand by sustaining two concurrent petitions before the same court in different stations, with the hope that in one of those court stations she will get a favorable outcome. And therefore, because she has acted with unclean hands, my lord, the proper thing for this court to do is to down its tools with regard to determining the allegation by the petitioner on that particular issue. Those are the only...
Council Fire, just a moment.
Yes, my lord.
Sorry for interjecting. That other matter was between the petitioner and the county assembly.
Yes, my lord.
Were you in that matter?
The court assembly was in that matter, my lord.
Were these proceedings brought to the attention of my brother Weru?
No, my lord.
Thank you. Mr. Ngoy?
Your Lordship, before Council takes over, I just want to...
Look, I've gotten enough. I've also placed you on notice that there's a potentially determinative decision of the High Court recently delivered. I think I've done what the law requires me to do. Councillor Ngoy, proceed. Unless...
Thank you. If I may, my lord,
yes.
for the county assembly, just 1 minute. My lord, there's another potential danger, my lord.
Yes.
With treating that ruling as having settled that issue. Because for the faith interested party, my lord, our position is that that ruling is per incuriam. That ruling was made without regard to the relevant law on content of court proceedings. And if it is treated, my lord,
Council, it's a pending matter.
I'm getting, my lord, and that is why, my lord, I'm saying that if this court was to treat that ruling as determinant of that issue, and the Court of Appeal ultimately reverses that ruling, it will create a very untidy situation, my lord.
The law and precedent that guides judges requires a judge, when something has happened and parties perhaps have not had the opportunity to address it in their written submissions, the judge must bring it to the attention of parties. I have done that. I am also required to get a feel of it, which I have done. I have also given you a very clear direction that when your time comes, I will add time so that you're able to canvass that extensively. Let the petitioner proceed.
Thank you. Well, for my law studies, I had interest in literature.
Yes.
Chinua Achebe taught me that an old woman feels very uncomfortable when dry bones are mentioned. So I'll proceed. At paragraph 35,
yes,
the brother finds as follows, that it is immaterial that the clerk of the county assembly, the deponent of the respondent's replying affidavit, believed it to be inconceivable that the court granted the said orders without first determining whether it had jurisdiction, or it granted, quote unquote, a blanket order effectively shielding the petitioner from present and future impeachment processes. Judicial authority of the sovereign state of Kenya lies with the court, and the members of the county assembly could not validly second guess the orders of court. I emphasize the words, could not validly second guess the orders of court. I make a submission here that the second guessing of the orders of court has thereby been declared to be invalid when the court says it could not validly second guess the orders of court. It behoves them to seek the review, setting aside, or variation of the order, not to act in a manner contrary to the order merely because they believed it not conceivable that the order could have been issued by the court. Conclusion. Clearly, the respondents were in contempt of court. That's a definitive finding. To withdraw a notice of impeachment against which orders have been issued by a court, and to introduce a fresh impeachment process outside the one subject of a court proceedings in which the court has made injunctive relief, so as to defeat the effect of the court order, is similar to withdrawing a suit in which an order restraining certain conduct has been made, so as to defeat the said court order. It is a classical textbook case of disobedience of court orders, albeit in a crafty manner. It is gaming the system of the rule of law that binds the three arms of government in mutual respect of separation of powers. My Lord, let me emphasize the fact that the gamers that the judge is referring to are the fourth interested party for you, and the sixth interested party, Zipporah Kenya. The court has described them in a formal ruling of court as gamers. The deputy leader of the majority withdrew notice of motion for the removal of the office, from the office of governor of Meru County on 30th July 2024, and issued a fresh notice of motion for removal of governor on 31st July 2024. For the record, my Lord, I just wish one day we'll get to know who advised the MCAs to take this act. I hope they were not lawyers before this court. It's my sincere hope. With respect, the court did not purport or pretend to grant, as submitted by the respondents, immunity to the petitioner against the accountability mechanisms under Article 181 of the Constitution and Section 33 of the County Government Act. All the court did was to hold the status quo pending the inter partes hearing and determination of the serious dispute presented by the petitioner in her petition. When the respondents proceeded with the process of impeachment of the petitioner, despite and indeed in spite of those orders, the respondents were in clear and mitigated contempt of court. These are the findings of the High Court. The County Assembly of Meru was in clear and mitigated contempt of court. If it were permissible to withdraw cases in which adverse orders have been made to avoid having to comply with the orders, no case would ever be heard to conclusion, as the suit will be withdrawn by the unsuccessful plaintiff or the injurious act abandoned and fresh wrongful act commenced by the debarred defendant whenever orders adverse to the party are made, and the respondent who stood to benefit from the orders will lose confidence in the system of justice. It will be a clear case of subversion of the rule of law and sabotage of the justice system, which the court cannot countenance. Orders. Accordingly, for the reasons set out above, the court makes the following orders on the application dated 1st August 2024. Number one, the respondents were guilty of contempt of court, and the appropriate relief within the meaning of Article 23(3) of the Constitution in this case against the named members of the County Assembly of Meru is a declaration that the respondent is in contempt of court, which the court hereby grants. Of course, the court proceeded to punish them as permitted by law. To the factual question, was this impeachment process undertaken in violation of the orders of court that were valid and in force? The petitioner's simple and straightforward answer is as follows: yes. Why? Because a court of law has determined it. It is authoritatively determined by a court of competent jurisdiction that the fourth interested party, the fifth interested party, and the sixth interested party are contemnors of court, and that they instituted and undertook impeachment of the petitioner in contempt of court.
Yes.
The respondent is established under our constitution as an institution of checks and balances. The Senate exists as an institution of checks and balances. It is not for fun that the framers of our constitution made impeachment of governors a two-tier process. The County Assembly and at the Senate. It was to ensure that each of these institutions acts as checkmates.
Yes.
It has been demonstrated factually, my lord, that the respondent's attention was drawn to these orders of court, and the respondent chose to perpetuate, to compound that contempt. Leaving only one question for determination. In view of this clear and unambiguous contempt, what are the consequences? The answer is to be found in volume 10A, the case of Honorable Martin Nyaga Wambora and 4 others versus the Speaker of the Senate and 6 others. The same respondent before you, my lord.
Yes.
And it's very curious that 10 years, a decade before this contempt of court, a decade before this, the court had warned the respondent before you of the consequences of this kind of actions.
Yes.
At paragraph 281 and 282, the court will find the consequences of this action, and I quote, "We, however, find the reasoning in Clark and others versus Chadban and others, 1985, volume 1, OER, page 211, most attractive in regard to our instant case. In this case, it was held, and I quote, an act done in willful disobedience of an injunctive or court order was not only contempt of court, but also an illegal and invalid act, which could not, therefore, effect any change in the rights and liabilities of others. I need not cite authority for the proposition that it is of high importance that the orders of courts should be obeyed. Willful disobedience may properly be described as being illegal. If by such disobedience the persons enjoined claim that they have validly effected some change in the rights and liabilities of others, as the respondent purported to effect change in the status of the petitioner before you as governor of Meru County, I cannot see why it should be said that although they are liable to penalties for contempt of court for doing what they did, which is what the court in Meru has done, nevertheless, those acts were validly done. But the legal consequences of what has to be done in breach of the law may plainly be very much affected by illegality. It seems to me, on principle, that those who defy a prohibition ought not to be able to claim that the fruits of their defiance are good and not tainted with illegality that produced them, even if the defendants thought that the injunction was properly obtained. Just as counsel for the interested parties have tried to tell you, they think that the order was improperly obtained, or too wide in its terms, that it provides no excuse for disobeying. The remedy is to vary or discharge it. We are in agreement with the above authorities to the effect that anything done in disobedience of court orders is null and void ab initio, and it is a nullity in law. Therefore, The sixth respondent, having proceeded to pass a resolution for the removal of the first petitioner from office in defiance of court order, means that the resolution was a nullity. It is like that the resolution was never passed in the first place. In the circumstances, there was no valid resolution which could have been forwarded to the Speaker of the Senate for action under Section 33(2) of the Act. The subsequent actions of the Senate are a nullity, including the decision to remove the first petitioner from office. These are the kind of cases, my Lord, that counsel may pause and say are on all fours with the facts and the circumstances before you. In a proper system of legal practice, counsel for the respondent and the affected interested parties would by now have sought out the petitioner for an appropriate consent to settle this matter. But we are where we are. You have to do duty. In concluding on this question,
Yes.
we submit that the petition before you can very well be disposed of on that issue alone. That issue affects the entire petition, even without going to other process and merit review issues. I'll therefore take just the next 5 minutes to submit on the other two issues, then invite my learned colleague, Mr. Mutuma.
Yes.
On the question whether the Senate proceeded with matters that were sub judice, again, I'll just make a simple reference to volume 1A of the petitioner's document, in particular at page 342. That page is a continuation of the Hansard of the afternoon of 20th August 2024 before the Senate of Kenya. At the third last paragraph, the attention of the Senate was brought to the following facts. I said then, and I say now, that the second set of matters I want to deal with are...
Just a moment. Yes, the second set of matters I want to deal with.
The second set of matters I want to deal with are pending active litigation in court as we stand here today. What I will describe as matters that are sub judice. Count number 1, paragraph 1 of the impeachment motion alleges that the governor illegally revoked the appointment of CPA Virginia Kawira Miriti as the Chief Executive Officer, CEO of the Meru County Public Service Board. Distinguished senators, it is not in dispute that this matter is pending active litigation at Meru Employment and Labor Relations Court, case number E002 of 2024, CPA Virginia Kawira Miriti versus the governor, Meru County. The governor invites the Senate to consider, as a matter of principle, what is its policy on matters sub judice? What is the policy of this Senate on matters that are pending active litigation before other courts of before other competent institutions of dispute resolution? My Lord, factually you will see that the issue was raised, the case in respect of which the pending matter was existing was drawn to the attention of the Senate, and therefore the Senate could not plead ignorance on having proceeded with that matter that was pending for a court of law. Evidence of the pendency of that case has been supplied in volume 2 of the governor's documents at page 14. Another matter that the governor wants you to apply the same mind on, matters that are actively pending in court, is what I referred to earlier as count 1, paragraph 4, on the alleged dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Mbaye, and Joseph Kithure Mberia. Madam Temporary Speaker, in addition to the fact that this is a matter that this Senate has already applied its mind on, Mr. Mutuma will submit on that issue, that this same fact involving these same people, involving this same transaction, had been a subject of impeachment in November 2023, and the governor had been acquitted of that fact. The same fact involving the same people, the same transaction, is brought to the Senate in August 2024, and the governor is convicted. Mr. Mutuma will deal with that aspect of this limb later on in our submissions. So I proceeded that it is not in dispute that this matter has been and continues to be in active litigation. This matter went to court as Meru Employment and Labor Relations Court Petition number 1 of 2022 and is now pending appeal. Evidence of the pendency of that appeal process is at page 71, volume 1B of the governor's documents. Again, my lord, the Senate had its attention specifically drawn to the pendency of this matter before a court of law. With tremendous humility, I invite this House to take this as a question of principle. What is the legal policy of this Senate on matters that are actively pending in our courts, such as paragraph 4, count number 1 of this impeachment motion? If you look at ground number 2, paragraph 6, and ground 3, paragraph 11 of the impeachment motion in the County Assembly's documents, volume 1, this matter relates to the case of one Daniel Mudiani alias Sniper and the contributions towards his family and the role connection of Kiambi Christmas Manyara as an accused person in that matter. The County Assembly at volume number 2 of its documents at page 429 has supplied this court with a charge sheet of that murder case. I beseech you, distinguished senators, to again make a principled decision in a matter such as this, where the County Assembly, by its own documents, admits that it is a matter pending active trial in our High Court. What is the policy of the Senate towards matters such as those? In summary, my lords, the Senate's attention was clearly drawn to matters sub judice. Standing Order number 103 of the Senate Standing Orders prohibits members from discussing matters in issue directly and substantially before a court of competent jurisdiction.
From discussing matters that
are in issue directly and substantially before a court of competent jurisdiction. That's the Senate's own standing orders. In our case, the respondent before you allowed discussion of these matters and resolution on these matters to the detriment of the petitioner, in violation of the Senate's own rules.
Yes.
We urge that this motion is for allowing on that ground again. Finally, on the question of fair trial, the factual basis will come out later when we play the video clips. At the tail end of the Senate trial, the petitioner was entitled to address the Senate before a resolution was passed. The petitioner in person was allowed to stand and address the Senate before a resolution was passed. Senate then broke into pandemonium. The decision maker himself broke into pandemonium. There was complete disorder, as my lord will get from the Hansard that is before you. There was complete disorder. As a consequence, the Senate itself prevented the governor from addressing it out of its own pandemonium.
Yes.
If this court were to give me permission to address it as it has done now, then break into pandemonium itself. No involvement of the governor at all. The Senate itself members of the Senate themselves. The video clips will show a very shameful development. At page 354 of the Hansard at volume 1A, you will see Senate has a very interesting, Parliament generally by tradition has an interesting way of calling noise. It calls noise loud consultations. So you will see multiple references to loud consultations. Just before the speaker holds Boni Halwale to be out of order, then you will see again loud consultations, then loud consultations. So you will notice that these multiple references to loud consultations progress on page 355. All these, my lords, are noisy sessions. It is Senate's own decorum sanitizing its documents out of tradition. We don't blame them. Out of tradition for consumption of the outside world. This is the environment in which the governor was treated first. So she was denied a chance to be heard, which she is entitled to by the rules of procedure involving impeachment in plenary. She is entitled to be heard. We urge that impeachment of the governor before the Senate constitutes a dispute that can be resolved by application of law within the meaning of Article 50 of the Constitution. That motion itself constitutes a dispute that can be resolved by application of law. And therefore, the petitioner was entitled to a fair hearing before the Senate, and denying her that opportunity to be heard by Senate's own breakdown of order violated her right. On those three grounds, I'll be inviting this court to make a finding in favor of the petitioner and, in substance, quash the resolution of the Senate. Allow me to invite my learned colleague, Mr. Elias Mutuma, to carry on from there. My Lord, perhaps we'll start by getting a time indication of how much time I've spent and how much time my learned colleague has, just for time management.
You have, you were to stop at 1:15. You will now be stopping at 1:40. But remember, Council Mutuma, you have video that you said is about 40 minutes.
Yes.
And there's also a first interested party who would require about 10 minutes.
Thank you, Your Lordship. I will address you on the remaining three issues. My learned senior has done a good job, and therefore I will not go so far with the issue of the right to fair hearing, save for just giving you the constitutional background of the same. My main address to you, Your Lordship, will be on the constitutionality of Section 33(8) of the County Governments Act and how that provision of the law limits the right to fair hearing and contravenes the provisions of Article 50(2)(o) of the Constitution. My Lord, the petitioner has moved this court and has invoked three specific and exclusive jurisdictions as found under Article 165 of the Constitution.
Yes.
The first jurisdiction that has been invoked is for Your Lordship to exercise your original and exclusive jurisdiction to determine whether a fundamental right under the Bill of Rights has been denied, threatened, or violated. 165(3)(b). To that extent, Your Lordship, we will be demonstrating that the respondent in this instance violated the right to fair hearing. Second, and most importantly, Your Lordship, is that you've been invited to exercise your jurisdiction under Article 165(3)(d) to interpret the Constitution, in this case Article 52(o), and how it sits with the provisions of Section 33(8) of the County Government Act.
Yes.
The last piece of jurisdiction that has been invoked, Your Lordship, is to exercise your jurisdiction and determine whether any act said to be done under the authority of this Constitution or any other law is inconsistent with the provisions of this Constitution.
Yes.
Your Lordship, the last aspect has been addressed comprehensively. That the respondent in this matter, Senate, purported to discharge or perform certain acts which did not have the backing of the law because the High Court in Meru had expressly barred that from happening.
Yes.
My Lord, since we are interested in looking at a determination on the question of whether a right was violated, allow me go quickly to Article 19 of the Constitution.
Yes.
Specifically 19(2), and this is what states: the purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals and communities and to promote social justice and the realization of the potential of all human beings. 3, the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. That is very important to me, Your Lordship, that the rights and freedoms under the Bill of Rights, they belong to each and every individual. They are not granted by the state, not the County Assembly of Meru, not the Senate, not even this court. We are born with those rights.
Yes.
I move to Article 20 on the application of the Bill of Rights. Under subclause 1, the Bill of Rights applies to all law and binds all state organs and all persons. There is a reason why, my Lord, I am emphasizing on all persons, every individual. And now 22 says, every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature of the rights or the fundamental freedom.
Yes.
Then the Constitution places an obligation upon you, Your Lordship, under subclause 3 of Article 20. In applying a provision of the Bill of Rights, a court
Yes.
In applying a provision of the Bill of Rights, a court shall, I jump to 3B, adopt an interpretation that most favors the enforcement of a right of fundamental freedom. 4, in interpreting the Bill of Rights, a court or tribunal or any other authority shall promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom. My Lord, the reason why I've taken you through that journey is because when you look at the respondent's response alongside those of the interested parties opposed to this petition,
Yes.
I've argued that the petitioner cannot enjoy the rights under Article 50(2)(o) of the Constitution. That is what they will stand to tell you. But my Lord, Article 19 and 20 talks about every person. The petitioner certainly is a person.
Yes.
The very specific article start by stating the following. My Lord, Article 50(o). It says, every 52(o), Your Lordship, every accused person has a right to a fair trial, sorry. Every accused person has a right to a fair trial, which includes, straight I jump to O, not to be tried for an offense in respect of an act or omission for which the accused person has previously been either acquitted or convicted of. In very clear and plain English. I urge Your Lordship to apply a literal meaning to the application of Article 52(o). Now, the respondents, alongside the interested parties, will argue that the rights under Article 50 are only available to a person facing criminal charges, exclusively. For the word they have used is purely in criminal matters. But my Lord, those are their words. I have combed through Article 50. I do not see any reference to criminal proceedings. Let's begin from where the article starts. Every person, Your Lordship.
Just a moment, Counsel.
Yes.
So that I understand your point.
Yes.
Just read the opening line of Article 50, Clause 2.
I'm there. That's actually where I was going, Your Lordship.
Yes.
That every person, starting from one. Yes. I'm beginning from one.
Not from one. Beginning from two.
Yes.
One is not.
Correct. Correct, Your Lordship.
Not in dispute.
Correct.
You all know how one applies.
Correct, Your Lordship.
Yes.
Every accused person has the right to a fair trial, which includes. The instructive words there is every accused person has a right to a fair trial. So the person to whom Article 50 applies, number one, must have been accused. Not in a criminal trial, because that is not in the Constitution, but he is standing in the position of an accused person. Has a right to a fair trial. Therefore, they must be facing a trial.
Yes.
So the question is, was the petitioner facing a trial? Was she standing in the position of an accused person? And the answer is yes. Your Lordship, there is a reason why Article 19 says that in your interpretation, you must give benefit to the person who alleges the right has been violated, so that they must enjoy that right to the greatest extent possible.
Yes.
There is a reason that's why that provision appears. My Lord, I have no time to go through the Hansard. But when you look at the mode of operation of the Senate, is that the governor, the petitioner in this case, is required, number one, to plead to the charges in person. If she pleads guilty, and guilty is a term that we all know is applicable in a criminal trial or even a quasi-criminal trial.
Just a moment. Yes, proceed.
But I refer you to volume 1A and at page 11, all the way. Hello, are you with me?
Yes. The charges against you as received from the County Assembly of Meru are
Correct.
as follows?
Yes.
Yes.
So the petitioner is required to plead. Charges are read to her. The particulars of the offense are read to her. and she is required to plead either guilty or not. Should she plead guilty, end of the case, she is convicted. A verdict is rendered. If she pleads not guilty, a trial commences. And what is the nature of this trial, Your Lordship? It is a replica of what transpires in a criminal setup, criminal proceeding setup, complete with the prosecution on one side and defense on the other. Complete with examination in chief, cross-examination, and re-examination.
Yes.
So the literal and plain meaning of Article 52, Your Lordship, is that that right is available to a person who has been accused and a person facing trial. There is no doubt in our minds, Your Lordship, and there should not be any. Yes, Your Lordship.
Just so that I record this.
Yes.
Page 12, the clerk of the Senate. It's about the third. Sorry, it's 1, 2, 3, 4, 5, 6 paragraphs from the bottom,
Yes.
just below Roman numeral 4.
Yes.
Just please read that.
Yes, Honorable Kwina Mwangaza, how do you plead to the 3 charges? Guilty or not guilty? The governor in response states, not guilty.
So it's the petitioner's submission that the Senate's use of that nomenclature invites Article 50, Clause 2O.
Indeed, in that it
So
presents.
if the civil court
Yes.
used that nomenclature,
Yes.
would it then also apply?
My Lord, I was very clear from the beginning.
Yes.
Article 52 is not only applicable to a person facing criminal charges exclusively.
Let's look at Article 52, let's take H.
Yes, yes.
Article 50, Clause 2, Paragraph H.
Yes.
Please read it out.
To have an advocate assigned to the accused person by the state and at state expense if substantial injustice would otherwise result, and to be informed of this right promptly.
Where does this occur?
This, Your Lordship, will occur in my experience of practice in murder cases. The state will provide counsel.
This right is read out in criminal proceedings. alone.
Indeed, Your Lordship.
Alone.
My point is this, Your Lordship,
Yes.
that the application of Article 52 is both to criminal cases and any other person facing a trial who has been accused of certain violations and who has a personal consequence of the outcome.
Yes, please proceed.
Indeed, Your Lordship, inasmuch as you're seated in a civil matter today, if there is contempt of court, inasmuch as this court is not a criminal court conducting a criminal trial, it will invoke Article 50 in sentencing or in taking the necessary action against the contempt law. And that, like in the case of Meru. So it cannot then be said that Article 50 can only apply to people facing criminal trials. If the framers of the Constitution wanted Article 50 to purely apply to criminal cases, they would have said so in this provision.
Yes.
The choice of the words here, Your Lordship, is deliberate by the framers of the Constitution. And just to confirm that point, Your Lordship, when you go to Article 50, It says every person has a right to have any dispute that can be resolved by the application of the law decided in a fair and public hearing before a court, one, if appropriate, another independent and impartial tribunal or body. So it was clear in the mind of the framers that there are people who will be facing trials, not necessarily criminal, and they will need to enjoy the right to fair hearing.
So that I understand your submission, so some of the rights in Article 50 Clause 2 would necessarily be purely for criminal.
Absolutely.
Some would apply.
Absolutely, Your Lordship. But the fact that some purely apply to criminal does not take away the right of other people facing trial to enjoy those rights.
I've understood that point.
Thank you, Your Lordship. Your Lordship, Article 24 and 25 of the Constitution. 25. I begin with 25, Your Lordship. I'm actually interested in 25. Despite any provision in this Constitution, the following rights and fundamental freedoms shall not be limited. Shall not be limited. One of those rights is the right to a fair trial.
Yes.
So when then the respondents argue and invite you to limit the right to fair trial of the petitioner as provided for under Article 50(2)(o), they are in essence inviting you to violate Article 25 of the Constitution.
Yes.
Therefore, Your Lordship, when Section 33(8) is enacted and purports to take away the right as expressly provided for under Article 52(o), then the provisions of Article 2 must kick in. The supremacy of this Constitution, Article 2(4), any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency. And any act or omission is in contravention of this Constitution, should be invalid. My Lord, we are in agreement that the Constitution is the supreme law of the land. It is the grand norm.
Yes.
Upon whom all other norms, including the County Governments Act, must derive their validity. Therefore, Section 33(8) must be declared unconstitutional by Your Lordship invoking your powers under Article 165
Yes.
to declare it inconsistent with Article 52(o) of the Constitution. Why? Because it allows a person who has faced a trial, a person who has been either convicted
Yes.
or discharged, to face similar charges. And now I move to the factual issue of that argument, Your Lordship. Let's look at the charges that the petitioner was facing.
I think, Councillor Mtuma,
Yes.
in the interest of time, because that is not in dispute. Yes, we can, we don't need to go so granular.
Thank you so much, Yellow. And in any case, we have highlighted
Yes.
the similarity between the charges that were preferred against the governor in 2023 and those that were preferred against her in 2024. Most importantly, Your Lordship,
Yes.
there has not been a denial from the respondents that indeed some of the charges that were preferred in 2023 were the same charges based on the same evidence. that were brought a year later. Surely, Your Lordship, there is a reason why the rule against double jeopardy exists. It is to prevent an abuse of the legal process, which is exactly what the County Assembly of Weru is doing. Taking advantage of an inconsistent section of section 33(8), to drag the petitioner in a court process, or rather in a trial process, even after she has been found not guilty of the charges. Having dispensed with that issue then, Your Lordship, allow me move to the right to fair trial as contravened by the respondent.
I believe you're now on 5, which is whether the threshold for the impeachment of the petitioner was in fact met.
Yes, Your Lordship, I'll address that as well. Your Lordship, we have already established that the right to fair trial is non-derogable. It cannot be limited. I also wish to submit, Your Lordship, that that right is continuous. Right from when charges are being drafted to when the final verdict is made.
Yes.
Again, Your Lordship, go back to Article 50. Article 50 says that every person has a right to have their dispute determined in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal or body. The words I want to capitalize on is impartial, independent.
Yes.
2A, to also be presumed innocent until the contrary is proven. That's a right that cannot be taken away whatsoever by dint of Article 25 of the Constitution. So did the respondent then act independently? Did they exercise impartiality? Did they presume the petitioner innocent and await evidence to prove the contrary? Then the answer is an emphatic no. They did not do that.
Yes.
Your Lordship, an old saying states that when the alligator comes out of the water and tells you that the crocodile is sick, you must believe it.
Yes.
The alligator has come out of the water, Your Lordship, and has come to tell us what we did at the Senate was a sham, was a mockery. We were under pressure. We needed to do this and get away with it.
Yes.
Why should we not believe them? That question.
Yes.
Your Lordship, on the issue of presumption of innocence, if, Your Lordship, today we would find a draft copy of a judgment in respect of this matter in your file, would you be said to be impartial? Could you be said to be sitting here to determine this matter on merit? The answer again is no. Your Lordship, it is not in dispute, and I will not be able to go to the factual basis of that, but voting at the Senate took place. The first count,
Yes.
a vote was taken on 21st of August 2024. That is not in dispute.
Yes.
But before that resolution, Your Lordship, I want to refer you to volume 1B at page 610. I was in Senate, the petitioner was in the Senate.
Yes.
And maybe my word does not mean anything, but let's just look before, as you place your finger on 610, Your Lordship, I want you to kindly move to volume 1A, page 365. 367, sorry. With your finger at 610, let's proceed to 367, volume 1A.
Mine is my volume, or you said 1A.
1A, yes, Your Lordship. So we have
367.
367.
Yes, I'm there.
We are in the Senate, Your Lordship.
Yes.
And the House is about to adjourn. And this is what the Speaker states. Honorable King, now you may be upstanding. Honorable Senators, there being no other business on the order paper, the Senate stands adjourned until Tuesday, 17 September 2024 at 2:30 p.m. Honorable Senators will be given priority to leave the chamber. Thereafter, the teams from the County Assembly and the Governor will follow, followed by the members of the public. The Senate rose at 1:09 a.m. on 21st of August 2024.
Just a moment. Yes, proceed.
But before that, Your Lordship, before the House adjourned, at 1:09 on 21st of August 2024, a communication had been done by the Clerk of the Senate. That is to be found at page 610, volume 1B. And this is what the communication states. First, it is addressed to the Clerk of the County Assembly of Meru, Mr. Jacob Kirari. Reference is decision of the Senate on the proposed removal from the office by impeachment of Honorable Kwina Weru Mwangaza, the Governor of Meru County. At its sitting held on 19th and 20th August 2024, the Senate, sitting in plenary, considered the proposed removal from the office by impeachment of Honorable Kwina Weru Mwangaza, the Governor of Meru County, and found the following particulars of the allegations against the Governor to have been substantiated. The three grounds are listed. Pursuant to the provisions of the Standing Order 48.2, I hereby transmit a message by the Speaker of the Senate conveying the decision of the Senate to the County Assembly. We will demonstrate through a video evidence that the last count was voted on 21st of August 2024 at 12:55.
Yes.
And I'm referring, Your Lordship, to BK M9, which appears on the same volume, page 639.
Yes.
You will come across protests by a number of senators who absconded the vote. And Your Lordship, at page 642, this is a protest letter by 15 senators who are present.
Yes.
And it says, at 12:55 a.m., we register our protestation under Standing Order 91-1B, as we were denied the right to debate. Of importance, this document,
the page number
642, Your Lordship, of Volume 1B. 642 of Volume 1B.
My 642 is not a letter.
It's a form, rather, Your Lordship, beginning with now, therefore, pursuant to Article.
Yes, yes.
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 My apologies. It's not a letter, you're right, Your Lordship. But let's look at the handwritten bit.
Yes.
It begins by a timestamp. It's at 12:55 a.m.
Yes.
In fact, better still, Your Lordship, because this document was pulled directly from the system. On the top right, there is a timestamp, in case anyone argues that this was concocted. And I can clearly see 2024 08 21 at 00:43 hours. This is the Senate's own system. I have not come across.
Yes.
Lordship.
Hear that objection too.
Just for the record,
Yes.
we object to that document in its entirety,
Yes.
but I feel it will be better to address it at the opportune time when we are responding to the issues raised.
I'm fairly certain we had case management in this matter. Quite a lengthy case management. When did you become aware of Volume 1B, Council?
Your Lordship,
When was it served on?
Your Lordship, the amended petition was served on 30th of December. 3rd January. Yes.
Okay, I'll reserve that objection. I've heard the objection. We will canvass it during your time.
Thank you, Your Lordship. In any case, just to address that issue, Your Lordship, nothing prevented the respondent, who is the custodian of this very document, to produce a document to counter what we have produced. Nothing. They have the originals, they have them in their custody. I would have expected counsel to produce a counter document, say it is not 00:43 hours. That has not been done. That benefit must be given to the petitioner, Your Lordship.
So that I'm clear, what turns on the time?
Your Lordship, what turns on the time is this.
Yes.
The communication by the clerk and the speaker of the Senate
Yes.
had a predetermined decision that was prepared, drafted, and signed in anticipation of the outcome.
Yes.
Because the only way you date a letter, you date the letter on the day you're working on it. We left chambers at 1:09. The last voting took place at 00:55. How could the speaker have communicated a decision that had not been arrived at hours before it was arrived at?
So the letter by the clerk is dated 20th.
Correct.
The voting takes place shortly after midnight on 21st.
Yes.
Yes.
So, to that extent, Your Lordship, we cannot then argue that there was a presumption of innocence as required of Article 52A of the Constitution. There was a predetermined decision. On the last issue, Your Lordship, of what, as I say, I have less than 40 minutes.
Yes.
Your Lordship, it is our submission that the environment prevailing at the time,
Yes.
just before the voting, was such that it could not allow. Your Lordship, with your permission, can my assistant approach
Yes, yes.
that
please.
desk?
I think this is a good point for us to watch
Thank you.
the video.
So I need not say much, Your Lordship, but we will witness chaos, anarchy, violence, shouting at the tail end, making it virtually impossible for any meaningful determination to take place. Your Lordship, as they sort out the technical bit,
Yes.
not only did the clerk and the speaker communicate to the county assembly of a decision that was yet to be made, but the speaker equally sent for publication of the resolution of the Senate hours before the determination was made. And it is for that reason that we are arguing that that Gazette notice itself, which is dated 20th of August 2024, but published on 21st, was prepared in anticipation of the resolutions by the Speaker.
Your Lordship, just for the record, we are also objecting to that, but we will submit on it at length. The video, actually the video is, Your Lordship.
The nature of an objection to a video should come before it is played. So let me hear your objection.
Your Lordship,
Yes.
first of all,
Just a moment.
I hope my time is frozen, Your Lordship.
Yes, it is.
Thank you.
Yes, may I have your objection?
Your Lordship, first of all, when this petition was filed, just from the facts of the case, a certificate of electronic evidence was sworn by one Maingi Brian Murithi.
Yes.
That certificate, it's actually an affidavit, Your Lordship. It was dated the 21st day of August 2024. Your Lordship, subsequently you gave leave for the petitioner to file an amended petition together with any other documents that they wish to rely upon for purposes of that petition, Your Lordship. Now, Your Lordship, subsequently we were served with the amended petition together with all the documents that they seek to rely on. Then, Your Lordship, when I was going through the documents, I found out, or rather I discovered, that there is some discrepancies in terms of the certificate of production of electronic evidence, Your Lordship. These I raised in my submissions, Your Lordship. My submissions are dated the 11th of February 2025, Your Lordship.
What is the discrepancy?
Now, Your Lordship, the first discrepancy was particularly for the videos marked, and I will list them, Your Lordship. For the videos marked BKM6, BKM7,
Yes.
KM7 and BKM9, KM10,
So the KM, the first KM.
KM7 and BKM9, KM10 and VKM1, Your Lordship. I raised the issue, Your Lordship, in my submissions
that the certificate produced therewith is defective and not compliant with Section 106 of the Evidence Act. The section, Your Lordship, gives clear details or clear provisions of what a certificate should contain, including the evidence that they seek to rely upon, Your Lordship. Now, Your Lordship, subsequently, after my submissions, on Tuesday, Your Lordship, I am served with another certificate by the same Brian Maingi Muridhi. And Your Lordship, this certificate is in essence attempting to cure the issues I have raised in the submissions, Your Lordship. Your Lordship can confirm from CTS when that certificate was filed, sorry. That was on Tuesday, Your Lordship. So, Your Lordship, at the very least, even just from the factual basis, without even going into everything, there needs to be a reciprocity between colleagues in the profession. We cannot operate like this, Your Lordship. I can't file submissions raising issues, and you simply serve me with a certificate, and you say that is enough. So then, the videos that are sought to be produced, in fact, Your Lordship, the ones that have been added are in red, and I'm referring to the certificate by Brian Muridhi. The same is dated 27th January, Your Lordship, and equally, Your Lordship, that certificate was served on Tuesday, but is backdated to 27th January, Your Lordship. And it was served on Tuesday. So then what is the fate of my submissions on this issue? Because a certificate is just produced and you're told, yeah, that is enough. Equally, Your Lordship, in these videos...
Councillor, just a moment. Councillor Tuma.
Yes.
What is your response?
I let my senior address you on that issue.
Sorry, my Lord.
No, just a moment. Let's take it limb by limb.
Okay.
Yes, Councillor Mwangaza?
Yes, my Lord, what Section 106 of the Evidence Act requires is that video evidence be accompanied by a certificate.
Yes.
So be supported by a certificate.
Yes.
My Lord, I don't know it to be the law. As a matter of principle, even going with the fact that the law, I don't know it to be the law that the certificate must be filed at the time of filing the video evidence. I don't know that to be the law.
Yes.
Indeed, my Lord, even if no certificate had been filed,
Yes.
there is no prohibition in law for the petitioner to supply that certificate now in court. There's no prohibition in law.
Yes.
As I understand it, the purpose of the certificate is to authenticate the video. The purpose of the certificate is to authenticate the video. So that without going into the other minor facts of when filed, because I need to cross-check with our filing team now to get those minor details, as a matter of fact, on principle, Council does not dispute that as we seek to play these videos today, there is a certificate authenticating that. So in view of that, in principle, I don't understand what substantive law has been violated in view of the concession that as we seek to play these videos now, there is a certificate backing each of the videos that we seek to play. There are other issues. Council referred to BKM as some of the videos. We have no videos under that label. We only have videos under KM7, KM10, and BKM1. So when you refer to, I had referred to BKM, those were just documentary annexures. So we're also trying to cross-check our documents just to confirm that there was no error in the branding, and I confirmed that there are no certificates under BKM. The first three.
What is the source of these three videos?
They are set out in the certificate as the various websites are set out in the certificate. The Senate's own website. the Senate's own website.
Your Lordship, I beg to differ. Particularly KM10 is from a YouTube video from a channel known as Kenya News Alert TV. How is that a Senate video?
Left my laptop. Does someone have a copy of these, of the 2 certificates? Did not be printed from my file.
Yes. If you look at volume number 9, at page 85 to page 89, is the certificate dated 27th January 2025. That's number 1.
Your Lordship, I can spare your time. I have both certificates here.
I think
That's thank you. While at it, again, the court will take judicial notice of the fact that our parliament has a parliamentary broadcasting unit. To my knowledge, and since counsel is with parliament, he can verify these facts if the contrary, is that broadcasts from parliament come through the parliamentary broadcasting unit. That's the primary source of all broadcasts of parliament.
Yes.
And number 3, and more importantly, if there was any material discrepancy in the content of the video, material, substantive discrepancy, since the parliamentary broadcasting unit under the control of the respondent is the primary broadcaster and primary repository of all these broadcasts, nothing was easier than then to bring us another video showing that here is the authentic video from the unit, and here is how.
Just a moment, Councilor.
Yes.
Just a moment. Is there a challenge to the authenticity of the videos?
Your Lordship, particularly the video on VKM10, which is and maybe that's not the one they were going to play, but Your Lordship, I don't know if I should keep objecting to the videos as they go or I just raise them all.
Well, let's sort this out at this juncture. I don't have a VKM referred to in the affidavit that you handed me. Sorry, the certificate you handed me.
Oh, sorry.
The one dated 27th January 2025.
Your Lordship, sorry, it's KM10. KM10.
VKM1, KM10, yes?
Yes.
What is wrong with KM10?
Your Lordship, this video is from an unknown account called Kenya News Alerts TV, Your Lordship. Even if I don't give another video to controvert that, Your Lordship, who is Kenya News Alerts TV? Can we call them here and cross-examine them about where they got this content, Your Lordship? It just is the law, or should we ask counsel?
So your objection is for KM10? Do you have a problem with VM1 and KM7?
Yes, Your Lordship.
So how do you on KM10, VKM1?
Your Lordship, this one was not even accessible. Let's even begin at the basic. It was not accessible, Your Lordship. VKM1. So we are here, we are playing videos, Your Lordship, like VKM1. I have not seen the video. I don't even know which best the approach to go about it, Your Lordship.
Let's watch the videos first.
My Lord,
Yes.
sorry. I just needed to contribute briefly on this and just help us move forward.
Yes.
By saying that counsel is very lucky because he's practicing when we have the 2010 Constitution.
Yes.
And what he's raising is what Article 159(2)(c) came to protect us against. Unnecessary and procedural objections on technicalities when the authenticity of the documents and the videos are not in question. If counsel was served by the petitioners in December or early January. What stopped him from sending any requests or saying, cancel, my video is not starting? So basically, let's proceed so that he's given an opportunity to submit on those videos when they are being seen. Otherwise, let's not bring in technicalities that don't go to the substance of this matter. Thank you.
Let's watch the videos. Let's
My
begin
Lord,
with...
I think you've got us out. We had an objection to the issue of the videos.
Yes.
A different limb altogether from what Mr. Mukele has raised.
Yes.
And if you allow me, Your Lordship,
Yes.
we took directions on the 18th of December on how we shall proceed today.
Yes.
Those directions were very categorical. We shall proceed by way of highlighting submissions.
Yes.
My Lord, I'm at pains to find a section in the Evidence Act that says that during highlighting of submissions, you can play videos. To my understanding, Your Lordship, that amounts to adducing evidence. It amounts to calling a witness to speak to the video so that then we can test the veracity and the authenticity of that particular evidence that is being portrayed in the video. My Lord, that was not the intention that we had when we gave directions on the 18th of December as to how we shall proceed today. My Lord, as if that is not enough.
Just a moment. Councillor Ngoya, on that point?
Just very briefly, we are proceeding on affidavit evidence. The affidavits have annexures. Where the annexures are written texts, like the Hansards and the letters, we read out as we have been doing. Where the annexures are videos, how else do you access videos? You will see them. The contrary is more unjust. The contrary is where we don't play these videos, but because it's evidence, the court goes and plays them without the benefit of the party's comment or observation. That would be more unjust even to the respondents. I mean, how would they see it completely? So, the playing of these videos is just a reference to the contents of the affidavit. The affidavit says, on this day there was pandemonium, evidence of that pandemonium is in this video. So we are not going outside affidavit evidence. We're actually just referring to the material in the affidavit evidence. My Lord, please plead with the learned colleagues to allow us to proceed with this hearing. We know why they fear these videos, we have no doubt about it, but it's in the nature of a trial. Some parts of a case are just unfavorable to you, and you live with it. You can't run away from it. Please allow us to proceed with the hearing.
My Lord, if I may clarify an issue before the court about just a minute on the issue of Section 106B of the Evidence Act and admissibility of the video there. My Lord, I refer you to the case of Republic versus Barista Y. Matugunda. My Lord, it's a 2011 case which interprets Section 106B and how parties should comply with the same. My Lord, the court said very clearly that this provision makes it abundantly clear that for electronic evidence to be deemed admissible, it must be accompanied by a certificate in terms of Section 106B. The question before the court, my Lord, is whether that evidence was accompanied by that certificate of electronic record. The petitioner has admitted that it was not accompanied by the same. They only filed it after it was raised by the Speaker of the Senate. It follows therefore, my Lord, it cannot be admitted before the court. It is tried by ambush, and the same thing should be struck out from the record, my Lord.
Sorry, my lord, and it's not my nature to do this. Could counsel have misled you in the authority he just cited a short while ago? Because he read a part of it and the authority says the contrary.
Yes.
Paragraph 30 of that authority, the court says, I am alive to the fact that the applicants are not fighting the contents of the document, but the lack of the certificate. I agree with the learned trial magistrate that it's in the interest of justice that the respondents be allowed to produce the certificate at that time in the trial, and for the court to deal with the evidence on its merits. The objection by the applicant is therefore overruled, and the application dismissed. This authority shows that an objection like theirs was overruled, and the party seeking to produce the certificate allowed to produce it. How can counsel cite an authority partially, particularly where it's not supplied in advance? Counsel has a strong ethical duty when citing an authority extempore to be extremely candid. Otherwise, the authority my learned colleague has referred to at paragraphs 30 to 31 of the ruling of your sister, sorry, my apologies, Justice Mbuati Matheka, which is the one she's referring to, I thought, says the exact opposite conclusion of the one he's inviting this court to find. That's revision number E006 of 2021. To the extent that's not the one, then there is authority to that effect. George Gabriel Gekuru and another versus Republic, where the court allowed a certificate on the day of the hearing and allowed the evidence to be referred to because there is no substantive contest on the content of the evidence.
My lord, I'm not sure whether counsel got the result of referred to. So the authority is Republic vs. Barisa Wayuma. It's a 2011 case, my lord. And the court concludes as follows. In fact, the court concludes that this provision makes it abundantly clear that for electronic evidence to be deemed admissible, it must be accompanied by a certificate in terms of section 106B. Without the required certificate, this CD, which was a CD in that case, is inadmissible as evidence, and I do rule the same. And the decision is by Justice Odero, my lord.
And my lord, to respond to what my senior Kansongoya raised about them being allowed to produce that certificate now.
Yes.
The meaning of the word accompany is ordinarily that those two must be brought at the same time, concurrently. And my lord, the issue here is not even mostly about that certificate. It is also about the accuracy and veracity of those videos, because we do not have the source of the videos. We do not have anybody we can cross-examine on the occurrences of those videos. For all we know, they could be AI generated. They could be deepfakes. The internet has advanced recently, my lord, and it's possible to do those things. There is no affidavit that is accompanying those videos. Therefore, there's no person we can put on the stand and cross-examine on the veracity and accuracy of those videos.
Let me give my short ruling on that. Counsel for the petitioner has conceded that the playing of the videos today would allow comment and observation by the parties. I agree with Counsel Kirimi in that regard, that it would blur the distinction between hearing and highlighting of written submissions. Counsel Mukele and Counsel Mwaria have, on the limb of objection on electronic certificates, have stated this is canvassed in their respective written submissions. Consequently, 1, the videos shall not be played today at highlighting, and the court shall view the videos through the stated links that are given in the petitioner's affidavits and certificates of production of electronic evidence. 2, the question of certificates shall be canvassed in the judgment as the certificates have been produced and we are past the hearing stage, and there is no question being raised to authenticity substantively. The objections are in the opposing party's written submissions. If the objections in the submission succeed, the court shall determine as much and not rely on the videos. Parties are reminded that in addition to adducing evidence, there is material in the public realm on this issue. So that's 21st February 2025. I've read the affidavits and I've read the written submissions. I understand, and I'm sure the opposing parties understand the direction that the videos being played today would have gone. The challenge is if you're opposing something that is already in the public realm, was canvassed on news reports, the judge may say, that's fine, I strike out the videos, but the judge cannot erase what the judge read in newspapers or saw on television. So that issue is dealt with, unless someone wants to raise another objection.
My Lord, not another objection, but in your ruling that you've just given, you have said that no objection has been raised to the authenticity.
You cannot say authenticity is we do not know. You cannot prove, you cannot assert a negative. You have to say this is AI generated because we ran it through software and it said this is AI generated content. We have very many publicly available software on this. It cannot be enough for you to say I don't know if it is authentic, therefore it should not be submitted.
We are guided, my Lord, but we hope our objection has been registered on the same.
Counsel. Counsel, please rise. Please rise. Counsel, which video is inauthentic? So that I record which video is.
Your Lordship, we contend that all of them are inauthentic.
Why?
Because we cannot test the veracity of those videos.
If you cannot test the veracity of the videos on the 21st of February for documents that were filed well back, what is the court supposed to do, counsel? You should have taken these links, you should have tested them, run them through freely available software. You cannot say you want to reserve something that you cannot prove.
Your Lordship, it's a law that a party that makes a certain assertion should prove it. It's the duty of the petitioner.
Prove your assertion that this could be AI generated.
And it is also the duty of the petitioner to provide reliable and authentic evidence.
You cannot say that something is inauthentic because you have not confirmed whether or not it is authentic. The certificate is supposed to give you the opportunity to then dispel the contentions that have been made. I will not record a reservation because I cannot see a reservation.
Your Lordship, I think we're in agreement, me and you. It's just you're in agreement because our issue is that this certificate was filed on the 18th of February, way after we had filed our submissions.
Let me give my view on that. My view has always been, even in private practice as a practitioner, you should object to something when it is being produced as an exhibit. Not even marked for identification, when it is then being produced as an exhibit. Because the party may elect never to produce it, so it will not be an exhibit. In civil trials, particularly in the way we have canvassed this petition, the moment we went beyond here, then whatever is on record is on record. Sadly, highlighting of written submissions is not the time to challenge. So the videos will not be played. I will access the links. If there's a link that is not working, as has been stated by one of the counsel opposing, then, and please don't change the links because you can't, it can't change the links. And I'm savvy enough to see if I look at the upload date, and the upload date is different. If the upload date is after the filing of this certificate, then we'll have a very, very big problem. So please don't tamper with the links. We were at the last name, I believe?
Yes, most glad, Your Lordship. Perhaps I may also want to point out that the respondent is the custodian of the website.
I will consider that in the...
Yes.
Let's not have any more on that. I'll consider it in the...
Thank you, Lordship. In the absence of the videos, Your Lordship, allow me submit, like I started by saying, that when the alligator comes out of the water and tells you that the crocodile is sick, then you must believe it, because it lives
this moment around, I think. Yes, Counsel?
Because the alligator lives in the same habitation with the crocodile, we have no reason to doubt it. The evidence that I'm about to rely on, say for the videos, are evidences of the judges. In this case, the senators, admitting themselves that what they did on the 19th and 20th and 21st of August
Yes.
was a mockery of the process. Why would we doubt them, Your Lordship? That would be the essence of video KM10, which will come across, Your Lordship. Senators in agreement that what they did in the Weru Kiri Mwangaza impeachment process did not meet the threshold.
I don't want us to reopen the videos.
Yes.
You have filed the Hansard, where in discussing another impeachment, some senators.
On that, we did not attach the Hansard, Your Lordship. We requested for it, but it never came in time. And by that time,
I'm sure I've seen it in the filings. I have seen it.
Your Lordship, all Hansards are available online.
most of that then I must admit. But yes, we just, the only problem with the Hansards, Your Lordship, like my learned senior was trying to explain, where we have chaos, the Hansards will report loud consultations. So if you do not have the benefit of the video, loud consultations translate to something else. And that was the essence of us producing those videos. So that
just so that I think I'll have to read it again.
Yes.
The videos shall not be played today at highlighting, and the court shall view the videos through the stated links that are given in the petitioner's affidavits and certificates of production of electronic. So I will view these. It is not fatal to your case that you are not having it today.
Thank you, Your Lordship. Your Lordship, at page 614 of volume 1B,
yes,
you will come across not a reporting, not just a newspaper cutting, but not just an opinion, but it is one of the judges telling the public through a newspaper of wide circulation of what transpired in the Senate. Senator Ledama Olekina. This is a person who sat as a judge.
just a moment.
Yes.
Councilor Mutuma, for the reasons that I will record, that this judge will not be able to consider that specific piece at page 614 quote. The judge informs the parties that the author of the piece reproduced at page 614 of the petitioner's volume 1B was related to this judge by way of marriage, and has been a long time family associate, having been written in his individual capacity, it would not be proper for this judge meant was the same unless the petitioner's case is essentially reliant on this court requests that the judge be permitted not to consider page 614 and only page 614.
Thank you, Your Lordship.
Any objection?
No objection, Your Lordship.
Anything from the respondent, interested parties? No objection?
My Lord, we thank you for that guidance.
Yes.
But even over and beyond that, there is no affidavit from...
It's a newspaper, can't say.
Absolutely. My Lord, for that document to be admissible, we would have expected, and for that document to have probative value, we would have expected them to have an affidavit from the person, from the senator, for it to be of use to this court.
Well, it's now much ado about nothing, because I will literally, with your
Indeed,
permission, I will literally fold it and we will staple it when we go back to my chambers. I would have cut it out, but the law requires me to preserve it the way it is. I can't be commenting on my brother-in-law's.
Thank you, Your Lordship. Luckily for the petitioner,
Yes.
there were 60 more judges sitting in Senate. And Senator Ledama was not the only judge that came out of the water to tell us that the crocodile was sick. At page 613
Yes.
of volume 1B, you will come across another judge by the name Senator Karen Nyamu in our official Facebook, and if given time, we can actually demonstrate.
I looked at this in chambers. I have already made up my mind. Facebook, let me say, social media posts are tricky for us as courts. You must authenticate that it is that actual person, not a parody.
Very well, Your Lordship. Allow me then.
So court finds that the petitioner was not satisfied with the requirements on proving the authorship and authenticity of the social media posts on page 613 of volume 1B. The same are struck out. Yes, please proceed.
I see my learned counsel is...
My Lord, we have another objection.
Yes.
My Lord, we thank you for the guidance that you just issued on the issue of the social media posts.
Yes.
My Lord, we bring to your attention that the petitioners, what in essence they are doing, they are actually reciting the answered property. And my learned friend is actually naming names, Honorable Senator Leda Mekina, Honorable Karen Nyamu as judges. And my Lord, we urge this court to treat all that as hearsay. As we see it, my Lord, there is no affidavit. They are telling you the judges are saying, the judge Karen Nyamu is saying, but there is no affidavit to authenticate that whether indeed that's their position on this matter as we are in court.
Councillor, I must confess, I'm a bit at a loss. I've struck it out, so there's nothing more I can do other than that. That would be the ultimate benefit you gain. What more would you like me to do? In 6:30?
That's okay for now.
Thank you. Yes, Council?
Your Lordship, I then swiftly move to the last link of my submissions. That is on the issue of public participation. I need not rehash.
Yes, as you're doing that,
Yes.
As you're on your feet, perhaps your colleagues who are seated can just confirm if the Hansard for, sorry, I can't recall the specific senator, but in the August House was addressing another impeachment proceeding and then referenced this proceeding. Please confirm if it is in your documents, if it is filed, or if it's any interested party. As you're proceeding, your colleagues can do that.
Thank you, Your Lordship. I need not belabor to take you through the importance and the application of public participation as envisaged under Article 10 of our Constitution. Allow me just go straight to the sham, the mockery that is purported to be the public participation that took place in the county of Meru that is related to the impeachment of the governor.
Yes.
Your Lordship, just to ensure that my learned friends will not object to the validity of this report, it is their own report. It is not my report, and it has been annexed by the fifth interested party, the County Assembly of Meru, as JK-41E.
JK-41?
41 in brackets E of their replying affidavit.
Dated? Replying affidavit dated?
I will get it shortly, Your Lordship.
It's all right. I'll leave that. Yes, please proceed.
Yes, as we get the date of the affidavit, Your Lordship, I will invite you to straight away look at pages, volume 4, pages 2071. Yes, it is the one dated 16th January 2025. I have confirmed the date, Your Lordship.
16th January 2025. You're saying volume 4?
Volume 4. I'm interested in looking at pages 2071, and we compare that to page 2076.
You said 2071?
Yes, 2071.
Of your volume 4?
Yes, we have labeled it at volume 4.
Mine ends at page 1385.
It is the fifth interested parties.
Oh, the fifth interested parties.
Correct.
Now, if we had brought all the hard copies, my writing space would have been non-existent. Could we request that the fifth IP perhaps lends us their copy?
So, you know, we have the soft copies of all the filings, so that if you can just play it on the screen. The filings were served in soft copy, so we have the volumes actually in soft copy. You can display them on the screen for ease of movement.
Now, he'd have to log in. My able Mr. Gui would have to log in.
My assistant is capable of doing that.
The time it will take.
Yes.
No one has a volume.
Your Lordship, I can lend you mine. Because I know
it permanently. I just need to refresh.
I can lend you mine, Your Lordship.
I just need to refresh my mind as to what it was.
There's another. Yes, Your Lordship.
Have a quick look. Page
2071.
Perhaps, my lord.
Yes.
So we went down to that page.
Yes.
I have an objection.
Yes.
My lord, the rule in Anarita Kariminjero on precision, in
Yes.
petitions, the petitioner ought to have set out with precision
Yes.
the particulars in support of that allegation. My lord, if you check the petition itself,
Yes.
no particulars have been provided. If you check the supporting affidavit, paragraph 19, the petitioner says that the evidence in support of the allegation of fabricated evidence of public participation is a 1344-page document, that is KM 6A and B of the petitioner's annexures. Our 1344-page document, my lord. No precision on where the specific allegation is, my lord. And if indeed the allegation is that the entire public participation report is fabricated, then, my lord, they should take us page by page through that entire 1344-page document to show the evidence of this fabrication.
Yes.
The only attempt, my lord, at providing the particulars.
Just a moment.
Very well, my lord.
So that I understand, you're objecting to the fifth interested parties document.
No, I'm objecting to the page that where the petitioner is leading to page 2021.
In the fifth interested parties document.
In the fifth interested parties document, my lord. The only pages they have provided, and it is in the submissions, my lord, not in the pleadings,
Yes.
are pages 2357.
If I sustain your objection,
Yes,
what
madam.
then becomes of those pages?
My lord, the point I'm making is this. The only particulars they have provided in support of the allegation of fabricated evidence are 4 pages.
Counsel, you have your opportunity. Today is highlighting of recent submissions.
Yes, madam.
You will have your opportunity to water down their case or completely defeat it. What you have stated is not, to my mind, in the nature of an objection. You're submitting that they have not met a drafting rule on precision and then an evidentiary bar. That you can take during your time.
My lord, my objection is this, my lord,
Yes.
that we are getting the particulars in support of that allegation for the first time now. It is trial by ambush. They should have in their petition pleaded with precision the pages of this entire document that they purport are fabricated. Without that, my lord, the fifth interested party will not wander around this entire document trying to discern what the petitioner complains is fabricated evidence. It is that simple, my lord.
Okay, let me get their point. I can see where you're coming from. Let me hear their point, then I'll know. Yes.
Trying to find out what Mr. Mawura is saying.
Yes.
That by referring to their own document, they are hearing of the contents of their own document for the first time now. I must concede sometimes I was law learner, my lord, but for a counsel to stand at the bar and suggest that referring to his own document is trial by ambush, I may require clarification as to what ambush means.
Counsel, as I stated earlier, I'm struggling because if I sustain your objection, then the only thing I can do is strike out those pages.
My lord, my request is not that you strike out those pages. Those pages are indeed, the pages they have put in their submissions are indeed in my bundle of documents, that is Annex K41E.
Yes.
My objection is very simple, my lord, that they ought to have provided the particulars of this fabricated evidence of public participation, whether in their annex, because this JK41E is the same as Annex KM6A and B in their documents.
So what we should do, because you've stated the 3 ingredients. 1, that it is already in their submissions. 2, that it's in your documents, it's in an opposing side's document. And 3, it's also been responded to in your submissions. I recall reading that there's not particulars. So is that really the nature of an objection, or is it you are arguing your side of the case before.
My lord, it is the nature of an objection, my lord, and I try to persuade you, my lord, because what the petition has done, and in fact their petition, they say that they provide the particulars at the hearing. My lord, in petitions, they ought to have told us, I am complaining about a specific page, which I say is a forgery, so that I am able to respond. My lord, if, and I know as a matter of fact, my lord, that they say that some of the people who are in those meetings, who are recorded in the minutes, did not attend those meetings, my lord. The prejudice on the part of the assembly is that even if I wanted to call a person to depose an affidavit to say that indeed I was present in that meeting, I would not be able to do so because I don't know.
Okay,
It is which meeting, in which one.
Let me frame it differently for you.
Yes.
So I can see where you're coming from. Council Ngoya or any other council with specificity. Sorry, that word just never goes off easily off my tongue. Could you point your court to where you have made an allegation of public participation not meeting the required threshold, being whatever it is that you are alleging within an affidavit petition, and then...
But also allow me, I explain this, Your Lordship.
Okay.
The volume 5 that we're talking about, as correctly stated by the fifth interested party,
You know about recording.
yes,
Did you get that close?
is a 3,000 plus page document. So even if we wanted to highlight each and every anomaly, we could not.
Did you cite any anomalies?
Yes, we did, Your Lordship. And we actually expressly say that we will then direct the court to the specific pages during the highlighting.
My lord, if you check the petition, the only place where they have mentioned public participation is the part of their participants. And in fact,
You mentioned in just that.
Just allow us some time, Your Lordship.
So I think it is a good time for us now to begin discussing one or two things. We are at 1 minute to 2. By my watch, because I stopped time, you had 13 minutes left. And then 10 minutes for the first interested parties, or rather the interested parties in support. That would take us to around, let's call it 2:30. How then do we proceed after that, to 2:30?
My Lord, with your kind permission,
Yes.
I had not been allocated time on behalf of the second interested party.
So I could give you 10:10. That would then take us to 2:33. Let's call it 2:35.
That's okay, thank you.
Are we going to break for lunch, or are we going to go? Yes.
So they had a come on record.
Yes.
Because not using my name for the second interested party.
Sorry, may I have your name again?
Which I'm aware is really second interested party. And we will be seeking less than 3 minutes maximum.
May I make a suggestion? Can we reconvene in, let's take a 20-minute break. That will then be in substitution to lunch. And we come back at 2:20. Everyone just grabs a quick cup of tea. We will continue from where we've left off.
Before we go, may I just, objections are coming very fast, and you can see the documents we have, so it takes a bit of time to trace material.
Yes.
What is sure is that every issue we have submitted on is available in our filings.
Yes. I'm not determining the objection.
Yes, correct.
All I've said is, let's take this, let's call it half an hour.
Correct. When I come back, I'll address on that
Half an hour.
issue of the particular
And
regulation.
grab a quick bite, as well as find that, and then we'll see whether the objection is sustained or it's over. Is that fine? So I'll see you all at 2:30 sharp.
Don't make noise. They can have
it should be non-negotiable. We shall finish this matter on Monday, come what may. Whether it means being here to 10 in the night,
yes.
We must commit ourselves that none of us is leaving on Monday without leaving the court again with judgment, having finished our business.
But it's easy for counsel to say, enough of less days to write a judgment, because I've fixed the date and it's not
correct. Yes.
going to move. Well, so that's fine.
Correct.
We can then do Monday.
Thank you.
And I will request for arrangements to be made.
Thank you.
Such that even if we leave here at midnight,
that's okay.
We'll have finished.
Thank you
so there was something before we broke. There was an objection as to the public participation. You want to lay some groundwork.
Thank you so much. So let me now go to that point directly. Volume number 1. Yes. Volume number 1 of the governance of the petitioner's document at page 37.
Yes.
There is paragraph 36, Roman 4.
Just a moment. You said page 36.
Page 37.
37.
37 days.
Roman 4.
Page paragraph 36. Roman 4. Are we there, my lord?
Yes.
It says the standard and mode of public participation. What standard and mode that ought to be attained to support an impeachment motion against a democratically elected governor in the face of a motion that relies on fabricated evidence of public participation. The law on pleadings as we know it is that you don't plead evidence, you plead facts. So that is a fact questioning public participation. The evidence is in the affidavit, and I'll move there, my lord, very briefly. Volume number 9. Volume number 9, at page number 9, I will take you from paragraphs 44.
Page number?
Number 9. That's the father affidavit sworn on.
Yes, on there.
Yes. So paragraph 44 So in response to the amended petition, the third interested party has asserted that public participation in support of my impeachment was duly carried out. However, there is evidence on record that the public participation as allegedly carried out was shambolic, stage managed, and a manifestation of work of fiction. Equally, in response to the fifth interested party's assertions that under paragraph 13, I note and highlight that whereas there was a public participation exercise, the same was shambolic and a mockery of the people's participation. That the various flaws eminent and apparent in the public participation memoranda shall be highlighted during the hearing of the instant suit. So there is a pleading questioning public participation. There is an averment of the shambolic nature of the public participation. The public participation report is in thousands of pages. We now want to start highlighting it. So to answer the objection, the matter has been pleaded, the matter has been particularized, and now it is time to point out to the various pages of the public participation report for this court's consideration. In any event, my lord, the purpose of particularization is to avoid an element of ambush. The interested party, I think is the fifth and sixth, concede that the public participation reports are part of their own filings before this court. It will be new jurisprudence if a party convinces this court that he has been ambushed by his own evidence. I rest.
Mr. Rejoinder?
Thank you, my lord. My lord, the basis of our objection is that the pleadings, be it the petition and the affidavit, provide no particulars. A general pleading that the public participation exercise was shambolic without any particulars. Please note down, my lord, that the petition and the affidavit provide no particulars to which the county assembly, as a body that undertook the public participation, would be able to respond. For instance, my lord, I believe it is in the further affidavit.
Yes.
At paragraph 46, the petitioner says that the flaws that are apparent in the public participation memoranda shall be highlighted during the instant of the hearing, during the hearing of the instant suit. As my lord, you noted before we broke, we are way past the stage of hearing. We are now at the highlighting of submissions. They ought to have provided the particulars in the pleadings so that the assembly, in preparing to respond, in fact, by failing to provide the particulars, the assembly was prevented from responding to those allegations. And the assembly will be hearing for the first time today and now that a certain memoranda, a certain attendance sheet for the public participation exercise is contested. The entire 44-page document, my lord,
yes,
is the public participation exercise that happened in all 45 wards. So without saying the specific document that they impugn, the county assembly is at a loss. And it is without doubt, my lord, that we will be unduly prejudiced if they provide that evidence for the first time now. It doesn't matter, and this document was prepared by the county assembly. In the Court of Appeal decision, my lord, in Mumo Atemu, it is at page 24 of the fifth interested parties, authorities. I'm going to read from, I think, Lord, what the Court of Appeal held. The petition before the High Court referred to Articles 1, 2, 3, 4, 10, 19, 20, and 73 of the Constitution in its title. However, the petition provided little or no particulars as to the allegations and the manner of the alleged infringements. For example, in paragraph 2 of the petition, the first respondent averred that the appointing organs ignored concerns touching of the integrity of the appellant. No particulars were enumerated. Further, paragraph 4 of the petition alleged and the government of Kenya overthrown the constitution, again without any particulars. Then the Court of Appeal goes on, paragraph 44, my lord. We wish to reaffirm the principle holding on this question in narrative and in general. In view of this, we find that the petition before the High Court did not meet the threshold established in that case. And the final ruling, my lord, is that it was not enough for the Superior Court, that is the High Court, to lament that the petition before it was not the epitome of precise, comprehensive, or elegant drafting without requiring remedy of the first respondent. So, my lord, if the petitioner is allowed to proceed and for the first time identify, for the first time inform the respondent and the interested parties, that of which they complain for the first time now, what remedy will the County Assembly have? Especially when they say, my lord, that some people did not attend. If the County Assembly wanted to provide evidence, and indeed those people attended those meetings, how would the County Assembly will do so if we will learn for the first time which specific meeting they are saying a particular individual did not attend, or which specific attendance sheet or minute sheet is forged? That is the basis of our objection, my lord. Thank you.
Thank you. So, Council Mawira, so that Mawira,
yes,
just so that I understand, it is your basis that there's an amplification. So it's not highlighting of written submissions, it's now amplification and going back to it.
Indeed, my lord, and that is what you noted in the morning, that we are way past that stage. They should have provided the particulars by the close of the week.
Then, my lord, I have to respond to that specific dimension now that he introduces.
Yes.
Yes. Because my learned colleague Mr. Mawira then says he's hearing for the first time. He has mentioned that word multiple times. For the first time. First, we have shown that the petition has pleaded deficiencies in public participation. We have shown that. Secondly, we have shown that the affidavits have also deponed to deficiencies in public participation.
Yes.
I don't understand it to be the case, my lord, that a party before you has an obligation to reproduce the contents of the annexures in the body of an affidavit. I do not understand that to be the law. That when you are making depositions in the affidavit, you then must go to the annexures and reproduce the contents in the body of the affidavit.
Yes.
But more importantly, in the written submissions, which we are now highlighting, so we are not amplifying, in the written submissions, which we are now highlighting, at page 135 of volume number 9,
yes.
At page 135 of volume number 9, you will see paragraph 225 under the theme non-existent participants in a public participation forum. Paragraph 25 refers to an affidavit, an annexure, and the pages where that allegation is. So we are here to highlight this. We are not here to amplify, we are here to highlight, to draw your attention to this content of our submissions. And therefore, my colleagues to suggest that if we draw your attention to paragraph 225 as I am doing, they'll be hearing of this paragraph for the first time now is a deficiency of truth. Because these are submissions duly filed and duly served upon all the parties, upon which this highlighting was predicated. So, my lord, let me say this so that we make progress. Objections are raised on admissibility of information or admissibility of material. Objections are not raised on the weight to be attached to material.
Yes.
Which is why I am finding it difficult to understand that in view of the claim we have made in the petition, which I have drawn your attention to, and in view of the depositions we have made in the father affidavit, how can this be an objection? What are they saying? That this material is not admissible? Or what is the objection? In fact, proper practice, my lord, is when a party stands and says, I object, he must state the objection. You must say, this is hearsay. That's the ground of objection. Then you specify. I am yet to understand the ground of objection. If my learned colleague's view was that the petition was incompetent, the petition itself was incompetent for want of particulars, that is not a ground of objection in submissions. That's a ground for striking out, which should have been done much earlier. And therefore, I urge that you overrule that objection and just allow Mr. Mutruma to complete his submissions. He has about just 10-20 minutes to finish his submissions.
My lord, if I may.
Yes.
Foremost, my lord, submissions are not political. And to the extent that council says they provided the particulars, paragraph 225, then he's admitting, my lord, that they did not provide the particulars. That allegation.
I didn't make that submission. I object to that line of submission. I never said particulars are paragraph 25. I alluded to the amended petition and I alluded to the affidavit of Kwina Weru Kiri, the father affidavit of 27th January. Then we submitted on those allegations in the submissions.
Well, at paragraph 225 of the written submissions, my lord, that is the only attempt by the petitioner to provide the particulars of the fabricated evidence. And it is tried law, my lord, that submissions are not complete. But for us to make progress, my lord, if the petitioner indeed limits herself to the pages she's provided in the submissions, that is page 2357, the 4 pages she cited in her submissions, because those are the only pages we have said, my lord, that we prepared in advance. Even if it was not in the application, we at least have notice of where the specific particulars in support of the allegation that we found. But for the other pages I had, Mr. Mutuma cited page 2071, that was not disclosed, my lord. Not in the petition, not even in the submission that we are trying to accommodate, my lord. So in view of that, my lord, I urge you to sustain my objection.
Court, the purpose of highlighting of written submissions is to give the court the benefit of the flavor, flow, and most impactful aspects of the relevant parties' written submissions. Highlighting of written submissions is and should always be distinct from a hearing. It would not be proper at the highlighting stage to amplify and connect dots of fact, evidence, or law that were not laid explicitly in the written submissions. To hold otherwise would be to allow at highlighting stage the expansion and amplification of the written submissions, which would prejudice opposing parties as they would need to have rebuttal in the form of perhaps written submissions. Paragraphs 225 to 231 under the subheading non-existent participants of the public participation fora must speak for themselves. And at highlighting, the petitioner cannot add substance or flesh out those paragraphs of the petitioner's written submissions dated 31st January 2025. This tension between what can be undertaken at hearing and what can be undertaken at highlighting can be easily resolved when one considers that it is possible and not uncommon for there to be a hearing, followed by the filing and exchange of written submissions, and thereafter highlighting of written submissions. Highlighting is to explain, argue, add flavor, and better flow to written submissions, and a party cannot and should not go beyond what was contained in the written submissions in arguing their case. In view of the foregoing, the objection is sustained and the petitioner shall be limited at highlighting to the express statements and documents stated at paragraphs 225 to 231 and to the annexures and pages referenced at paragraph 225, the case law at paragraph 229, and any other similar paragraphs on in her own or other parties' written submissions.
Yes, thank you for your ruling, Your Lordship.
Yes.
I will straight away direct you to the pages where we have highlighted and where we seem to have an issue with. Yes. My Lord, the public participation report before you was produced for a purpose. It was for the consumption of the court to analyze the memoranda therein and arrive at a factual determination of whether public participation indeed took place and of the quality and quantity of the public participation.
Yes.
A perusal of the said public participation report reveals that most of the memoranda therein were fabricated, concocted, and duplicated. to give an impression that the people of Meru who participated in this exercise, or purportedly who participated, supported the removal of the governor. Nothing can be further from the truth.
Yes.
Your Lordship, at volume 4, page 2071,
Just a moment.
I'm not sure whether that is the volume, Your Lordship, we can...
Or the
It is the
IPs.
Yes, we have extra copies. The
Yes, sir, I do
assistant
have
can-
my laptop.
we have an extra copy, Your Lordship. There are two. There's another one.
Page.
That's page 2071 of volume 4.
Yes.
You will come across a photograph that is captured purporting to be an image of the people who...
Now, Council, I've just delivered an extempore ruling on this aspect, sustaining an objection.
Yes.
The fifth interested party's objection is they should be able to read the written submissions, see an argument that is then being articulated, and you cannot reference a page that they have never been told.
Yes.
We have a problem with page 2071 of your volume 4 because it shows this.
And when you look at paragraph 227, appearing at page 135 of volume 9,
yes,
the petitioner has alluded to that fact.
Yes, the petitioner has alluded to that fact. That is not in dispute. What the petitioner has not done is draw the attention of the court, but more importantly, the opposing parties, to where that paragraph is going to go. That means that at highlighting stage, remember, all of you have already filed your submission. At highlighting stage, council will be for the first time being informed that the specific, the particularized allegation is that this shows 1, 2, 3, 4, 5, and it will not be safe.
Very well, Your Lordship. In that case then, because we believe that the court will have an obligation to go through the entire public participation report.
Yes.
But my understanding, we understood your ruling the way you have cast it. In fact, we were happy with that ruling.
Yes.
And that's why my learned colleague draws your attention to paragraph 227. But having said that, my lord,
yes.
If you, just without putting on record, I want you to tell me the implication of this.
Yes.
If you look at volume 1A.
Your volume 1.
Volume 1A.
Yes.
And you go to page 339.
Yes.
And you go to the second last paragraph.
Yes.
The one starting with, I would like to take these honorable senators through the public participation report.
Yes.
And you notice that there is specific reference to specific page numbers, to specific paragraphs of these same public participation reports. As a dispute between the petitioner, indeed before you, and the fifth respondent that was taking place before the respondent, the fifth interested party that was taking place before the respondent.
Yes.
And you can see...
Councilor, go ahead, just a moment.
Yes.
The distinction is when you were taking the honorable senators through, you were having a hearing. So you had the opportunity at hearing to chart your ship in whichever direction you wanted. What the opposing side is saying is, once we are past the hearing stage, you cannot at highlight do the same thing that was happening in the Senate. And that's a fair point.
Yes,
now, just so that we close this meeting, I would love to be able to have my work made easier for me by taking cross-references. But their point is very solid in law. This will be a reopening of hearing. If they were then to ask for leave to file supplementary submissions, just responding to this. And remember, your client has a sunset clause on the interim ownership. I doubt I would then be able. So with the, please listen to the court and let's not
Can I?
Sorry, I made a different point.
Yes.
The point I was making, if I had finished, it was as follows.
Yes.
That we have invited you to make a process review and a merit review of the Senate's decision. Merit review, you are asking yourself, looking at the material that was before it.
Yes.
Did the Senate arrive at the correct decision?
Yes.
Why I drew your attention to this is just to let you that the fact that we have drawn your attention to in the petition and in the affidavit is a public participation question, no doubt about it.
Yes.
The manner in which the Senate's attention was drawn to it is at page 339 all the way to page 342. The manner in which the Senate was drawn to it. So that what we are leaving you with is just a judicious challenge that this is the material the Senate had.
Yes.
Did it reach the correct finding on that question? That's all.
So just to put you at ease, before council also rises to the feet, I will go through each and every one of these bundles. I've already gone through most of them. I probably have a very, very good understanding of all of them. I would have loved it if there had been a cross-referencing, but that was not done. I will go through all of it. Just
Mine was just to highlight the fact that with the kind of trial advocacy we have, when you don't have a specific date for hearing, and you file your pleadings, you allege and you aver to facts, and then you have your evidence in support. When you don't actually have an opportunity to be heard, so to speak, but you are heard through pleadings, then those pleadings need to speak. And sometimes the only opportunity you have to have the pleadings speak is when you're highlighting submissions. So sometimes you can't help but to cross over to the evidence, because there's never an opportunity for oral hearing as such. So I was just requesting the court to take that into cognizance, because there's a question of how was the process done and what is the merit, and it therefore means that you may have to still look at the evidence.
I would invite counsel on both sides to note that the phrase is highlight of written submissions. Highlight. So you're highlighting something. And for those of us of a particular vintage, we had to literally take a highlighting pen and highlight, and then we had to do these tasks, particularly at the Court of Appeal, and you could not go outside of what you had highlighted in pen. So I will look at everything that is being argued. I will cross-reference it. But for us to have a safe and orderly flow, it cannot go outside of what has been filed in the form of written submissions. I must confess, I don't think it's a very significant issue, because I will still have to determine 6 points, and I will have to explain one way or the other my merit and law review of public participation. Whether or not it has been pleaded in written submissions, even if it had not been pleaded expressly, I think odd jobs, the case of odd jobs, gives very, very good guidance. I would still have had to deal with it in the judgment. So no prejudice is being suffered by the petitioner. The objection has been sustained.
Very well, Your Lordship. Allow me then proceed to the last issue of my submission.
Yes.
That is whether the threshold for impeachment of the petitioner was met.
Yes.
Your Lordship, time and again, this court, the Court of Appeal, and the Supreme Court have had the benefit of addressing themselves on the question of threshold.
Yes.
And from all the authorities that we have relied upon, it is clear that the removal from office of a governor cannot be hinged on just any other misdemeanor or wrongful acts.
Yes.
Specifically, Your Lordship, Article 181 of the Constitution is very clear that there are only 4 grounds upon which a governor can be removed from office. One is gross violation of the Constitution or any other law. Not in any way to demean a violation, because a violation is a violation, whether it is of huge magnitude or less magnitude. But the framers of the Constitution were very deliberate with the language. It has to be gross.
Yes.
Meaning that there are other violations of the Constitution and of the law that will not form the basis for removal of the governor by way of impeachment.
Yes.
So it is not enough then for the county assembly to just disclose a violation. They have the obligation to demonstrate the grossness of that violation.
Yes.
Throughout the pleadings at the Senate, looking at the notice of motion for impeachment, there has been no attempt to demonstrate the grossness of the violation alleged. What has been alleged is the violation, not the grossness part of it.
Yes.
The Supreme Court, Your Lordship, in the case of Sonko versus County Assembly of Nairobi City County versus 11 and 11 others, had the opportunity to define what gross violation is. I will not rehash the finding. It is then our submission, Your Lordship, that as a court sitting in review of the actions of a quasi-judicial body in your supervisory jurisdiction, you ought to go back to the charges and to the evidence and satisfy yourself that indeed the threshold was met. When you try to do that, Your Lordship, it will surprise you that the removal of the governor was based on employment disputes, which by whatever definition cannot qualify as gross violation. In any case, Your Lordship, closely related to that issue, is that the employment disputes in question for which the governor was impeached were matters that were active before the proper forum, that is the Employment and Labor Relations Court. That court is given the mandate by the Constitution and Statute to deal with employment disputes. It would then mean that the provisions of Article 35 on the right to political participation are being violated, sorry, that 34 of the Constitution, where the people of Meru make their choice in respect of who should be their governor, and all you need to do to overturn that will is just to find any administrative dispute and accuse the governor of it and seek to overturn that will.
So, Council, when I undertook a preliminary reading of the written submissions,
yes,
please turn to paragraph 202 of your submissions dated 31st January 2025.
I am there, Your Lordship, yes.
So those are the four. Which ones were, to the petitioner's mind, sub judice and pending before the ELRC? Of those four?
Very well, Your Lordship. The issue of paragraph D.
Yes.
Paying Christas Manyara, a public communication officer in the office of the governor, that was an issue that was sub judice. We have taken time. We have gone an extra mile, Your Lordship,
yes,
to create a table that demonstrates, and that is to be found at page 40 of our volume 1.
Just a moment.
Page 40 of volume 1.
Yes.
Count 1, Your Lordship, was on abuse of office. The particulars was that the governor was accused of illegally revoking the appointment of CPA Virginia Weru Kiri as a CEO of Meru County Public Service Board. This is a matter, Your Lordship, an employment dispute that at the time of hearing at the Senate was alive at Meru Employment and Labor Relations Court, case number E002 of 2024. The parties, Virginia Weru Kiri versus the governor, Meru County. It cannot then be in dispute, Your Lordship, that this cannot be a gross violation of the Constitution. It is an employment and labor relations dispute. And that's why it was forwarded for arbitration and determination to the right forum.
My Lord, pardon me.
Yes.
We are constrained to speak up because we are trying to access those volumes the way Council is referencing them. And we cannot see them either on the CTS. When you look for volume 1, volume 2, or volume 3, we cannot see it there. So we are not able to follow. And remember that the petitioner never served us these documents.
So there's an amended petition. If you
If I may-
get to page 12 of the amended petition, that's where you will find that table.
My Lord, that's not the problem. The problem is if they keep referring to volume this, volume that, we do not have that. We can't follow.
Your Lordship, if I may explain,
This
This is not a big issue. So, Council Mutuma, when you say volume 1,
Yes.
you then say what
Correct.
is the document and the page number.
I'm referring to the amended, the petitioner's supplementary affidavit at page 12. Amended petition.
4 grounds, yet in your other documents you have others that have been mentioned. So for example, count 2 and 3, that is referenced at that page 12.
I get your point, Your Lordship. Paragraph 202 is specifically talking about the ground on abuse of office. So under abuse of office, we had 4 links.
Yes.
So the ground itself is abuse of office. But underneath, you would, if you may, Your Lordship, count 1 to 4. Under that, 1 charge.
Okay.
Yes.
So that is only on abuse of office.
Correct.
Misconduct.
Correct, Your
It's
Lordship.
not on the rest.
Yes. Yes. Your Lordship, back at page 12.
Follow if I may.
Yes.
I think the point is that at page 12, count 2, page 12 of the amended petition, what the petitioner says is alleged murder, it is a misrepresentation. Because the allegation is as per what appears on page 2. Paying Kiambi Christians Manyara, it is not alleged murder. That is a deliberate misrepresentation of the impeachment allegation by the petitioner.
My Lord, I must now make it clear that it appears to me that there is an undisclosed strategy by the respondents and the supporting interested parties to disrupt the flow of thought of the petitioners as much as possible with a view to a collateral advantage. We are making submissions, my Lord. Each one of us has a benefit of something called train of thought. And if you look at the number of objections we have had today, it must now begin getting curious. My learned colleagues have a chance to reply a whole day on Monday to tell this court where misrepresentations are, where half-truths are, where falsehoods are. Please allow Mr. Mutuma to make out his case the best way he can. It cannot be fair to the petition for us to face this barrage of objections in the middle. There's no single sentence Mr. Mutuma makes that is allowed to complete. If Mr. Mutuma has made a statement that is factually incorrect in the face of the charges, my colleagues will refer to the charges and respond. It's only fair.
Thank you. Thank you, Your Lordship. Your Lordship, once again, just to demonstrate the fact that the charges as against the governor were nothing more than administrative issues that could have been, and indeed were, resolved in other forums. I'll move on to the next, rather the second count, the second limb of count 1, that is illegally dismissing Dr. Ndoiti, CEO County Revenue Board, Paul Mwaki, CEO Liquor Board, Kenneth Kimathi Mbaye, Managing Director Mary Microfinance Corporation, and Joseph Kiture.
Council, we covered this earlier. I
Yes.
recorded this
Yes.
earlier.
Yes.
So perhaps we can skip that.
Yes. So my point on this issue, Your Lordship, is that the framers of the Constitution did not envisage a situation where violations capable of being dispensed with, determined in a different forum, provided for by the Constitution and the law, would find their way as a ground for impeachment of a governor. Because they are not gross. Violations, yes, and we are not admitting that the governor was liable, but there were forums to address those issues. We have demonstrated indeed that those disputes, administrative in nature, employment disputes, were in other forums capable of addressing them. They cannot therefore then fit within the meaning of gross violation under Article 181.
Yes.
Not by the definition of the Supreme Court. Again, Your Lordship, the Supreme Court in the Supra case was very clear that there has to be a nexus between the violation complained of, and the acts of the petitioner.
Yes.
You will go through all the charges against the governor, Your Lordship, and you will find that to a larger extent, if not 100%, the acts complained of were of that parties and not those of the governor.
Yes.
That being the case, Your Lordship, then it cannot be argued that the threshold under Article 181 of the Constitution was met.
The Wambora case decision on nexus, can it also apply to command responsibility? Where we're saying the chief executive officer of a county has a command obligation to ensure that even if he or she is not the one who directly did something, they must exercise supervision and control to a required extent, failure to which then they are liable, equally liable.
Indeed, Your Lordship, one might want to approach it that way. But then, evidence must be established that the petitioner or the governor, in that case, willfully, number one, was aware of the violation by a third party and failed to take action, having been required by law to do that. At the Senate, Your Lordship,
yes,
we were able to demonstrate that even where resolutions were passed against certain individuals who are not the governor,
yes,
there was no evidence to indicate that that was brought to the attention of the governor, requiring her to take action.
yes,
So then squarely means that those action lay squarely with the people that had perpetuated them.
yes.
I have no time, Your Lordship, to go through each and every count,
Yes.
but I humbly request you to go through the motion as found at page 2144 of volume 6.
Yes.
All the way to the end of the motion. You will have no doubt in your mind, Your Lordship, that the charges against the governor could not meet the threshold of gross violation. In conclusion, Your Lordship, I want to submit that the governor has established a case for the following.
Yes.
One is that Article 181 of the Constitution,
Just a moment. Yes.
as read together with Section 33, and this time I'm referring to Section 33 as a whole, not 33(8),
Yes.
that any person seeking to invoke those two provisions must do so within the authority of the Constitution and the law.
Yes.
It has been established without a shadow of doubt that the respondents' fourth, fifth, and sixth respondents, interested parties rather, did not have the authority of the law to proceed with impeachment. For the simple reason that they had been prohibited expressly from proceeding with the impeachment process by a valid court order. As we speak, Your Lordship, the County Assembly of Meru
Yes. Yes.
The Speaker of County Assembly of Meru, the mover of the motion, one is Paul Akinya, are convicts. They have been found guilty.
The Speaker of the County Assembly.
The mover of the motion, one is Paul Akinya, and the County Assembly of Meru
Yes.
are convicts. A court of competent jurisdiction has sentenced them to a period of 6 months imprisonment. I am surprised to see that they are hovering around.
That's all. I will not record that.
Yes. What then needs to be done, Your Lordship, is for them first to purge the contempt, because very well, I will just stop at that. I will just stop at the fact that they are convicts.
Yes.
On the second issue, Your Lordship, the petitioner has been able to establish that her right to fair hearing has been, one, threatened to be violated by the County Assembly of Meru,
Yes.
and indeed violated by the respondent in this matter by failing the impartiality and independence tests as expected under Article 50 of the Constitution.
Yes.
By way of summary, Your Lordship, is that a decision was made to remove the petitioner before the actual voting took place, and indeed that decision was communicated. There is no other clear indication of lack of impartiality, lack of independence, and failing to uphold the right to presumption of innocence.
Yes.
That action alone is enough to demonstrate that the Senate was not only biased, but very much partial.
Yes.
Related to that, Your Lordship, is that we have been able to demonstrate
Yes.
that the County Assembly of Meru, together with the Senate, exploited an inconsistent provision of the law, that is section 33(8), and went against the rule of against double jeopardy. That is a violation of the right to fair hearing.
Is the proper term then inconsistent? Because I recorded at length where you were stating that it's unconstitutional. Isn't that the better word?
Yes, Your Lordship, inconsistent to that extent, therefore it has to be declared.
Inconsistent with the Constitution.
Yes, it is inconsistent with the Constitution, therefore must be declared unconstitutional.
Yes.
We invite the court to invoke its powers under Article 165 and declare that section as unconstitutional to prevent its abuse. Your Lordship, as you go through the public participation report, you will discover that there was no compliance with the principles under Article 10 of the Constitution. What has been presented to you is shambolic and a mockery of the process. Having done that, Your Lordship, unless I'm leaving out anything, the petitioner rests her case. Thank you so much, Your Lordship.
Thank you. So we have interested parties in support. Which interested parties are supporting the petition, and how much time would you need to highlight written submissions without repeating ground that was covered by the petitioner?
My apologies. We did put on record Mr. Desire Njamwea for the 7th interested party.
No, he did. Before we took the break,
okay.
He did.
Thank you, okay.
I'll begin with the first interested party.
Thank you, my lord.
Yes. How much time would you need? Confirm.
I had requested for 30. I'm not too sure with the developments and to avoid regurgitating what has already been stated by the petitioner.
Yes.
I can do a bit less than that, my lord.
You can do a lot less than that. Can we give you 10 minutes?
I'll endeavor to stick within the 10 minutes.
I'll stop writing at 10.
It's okay, my lord. I will try as much. My lord, we...
Just a moment. Second IP, presumably also in support?
My lord, yes, we are in support of the petition.
How much time?
15 minutes.
10 as well. That takes us to the 7th. 10 as well. You had said 3 before the break. Maybe the 7 extra.
Give me 6 minutes.
Let me give you the 10. So that's 10, 10, 10. So it's a combined 30 minutes. If one interested party takes less than that, I'll just add it to the next. So we'll start with the first interested party.
Thank you, my lord. On the part of the first interested party, my lord,
yes,
we wish to state that we filed a replying affidavit dated and filed on 14th January 2025 in response to the petition, rather the amended petition dated 23rd December 2024.
Yes.
Well, we also filed our written submissions dated 4th February 2025,
yes,
as well as a list of authorities dated 4th February 2025 and filed on even dates, my lord,
yes,
in support of the amended petition dated 23rd December 2024.
yes.
I wish to point out to the court that we associate fully with the submissions and the supplementary submissions filed and highlighted by the petitioner in this case.
Yes.
Well, the first interested party is established pursuant to the provisions of Section 19 of the Intergovernmental Relations Act, my lord.
Yes.
And the mandate of the first interested party, my lord,
Yes.
is then provided under the provisions of Section 20 of the said Act.
Yes.
The first interested party then coordinates the 47 county governments on matters of common interest with regards to the implementation of the resolution.
Yes.
We have then, the first interested party has then crystallized 5 issues for determination or for consideration by this Honorable Court in support of the petition. The first issue, and I'll read them in chronology, my lord,
Yes.
is whether the impeachment proceedings against the petitioner met the constitutional threshold as provided for under Article 181 of the Constitution,
Yes.
as read together with Section 33 of the County Governments Act. Secondly, my lord, is whether the actions of the 5th interested party, that is the County Assembly of Meru,
Yes.
amounts to an abuse of the impeachment process as an oversight and accountability tool.
Yes.
Third question, my Lord, is whether the impeachment process was procedurally flawed in violation of the principles of natural justice
Yes.
as laid out under the provisions of Article 47 as read together with Article 50 of the Constitution.
Yes.
The fourth issue concerns itself with whether Section 33, subsection 8 of the County Governments Act is unconstitutional for allowing repeated impeachment attempts over similar facts tried and tested by the relevant bodies. Finally, is whether it is in the public interest to allow the petition filed by the petitioner, my Lord. My Lord, as you permit me to venture into the first point.
You have just about 5 minutes.
Yes.
So perhaps I can guide. Your fifth limb is the one that, and I've had the benefit of already reading the submissions, is the one that perhaps has not been extensively canvassed by the petitioners, or perhaps more accurately, it is differently argued. So perhaps that is what I should highlight. Any strong points on that?
On the fifth point, my Lord?
Yes, whether it is in the public interest to allow the amendment petition.
Okay. Thank you, my Lord. I will just gloss over some of the issues to avoid regurgitating what has been said by my language colleagues, Mr. Mutuma and Mr. Ongoya. My Lord, it will suffice to state that presently there is no legislation that deals with the question of impeachment. There is no standalone legislation that deals with the question of impeachment.
Yes.
My Lord, this is so despite the specific provision of the Constitution, specifically Article 181, sub-Article 2, which states specifically that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified under subclause 1.
Yes.
My Lord, the County Governments Act has donated a section, just a simple section, as one section that deals with this question.
Yes.
The constitutional provision states that there has to be a standalone legislation to deal with that question, my Lord.
Yes.
My Lord, where does this leave us?
Yes.
This leaves the determination of impeachment processes to the jurisdiction, to the jurisprudence, my Lord, sorry about that,
Yes.
that has been set out in previous impeachment proceedings, my Lord.
Yes.
We are then guided by the judicial authorities. And the leading one, my Lord, being the case of Martin Wambora and 3 others versus the Speaker of the Senate, Civil Appeal number 21 of 2014, my Lord.
Yes.
In this particular case, my Lord,
Yes.
the court then emphasized that there is a need to maintain a high threshold for the removal of Governor, my lord.
Yes.
It also went ahead to lay out the standard of proof which is then required for the removal of a governor, my lord, which the court states is above a balance of probability, my lord. It goes ahead to say that there has to be a nexus between the governor and the alleged gross violation of the Constitution.
If you look at the petitioner's written submissions,
Yes.
their first set, the ones for 31st January 2025, they canvass that case and those limbs from paragraph 189 to paragraph 201. What they have not done in one conject, unlike in your written petitions, they've not addressed the question of expressing the public interest. And that is why I was guiding you to that.
Yes.
So that you, in the remaining 4 minutes, get to do that. We've all read Wambora, we all
Yes.
know the limits for it. But I was quite, I wanted you to flesh out your thinking on public interest.
Yes, my lord.
How it applies to it.
Thank you, my lord. I will then, but the point that I wanted to lay out, my lord,
Yes.
if you look at the charges vis-a-vis what has been set out under 181, there is use of the word gross violation. There is also use of the word abuse of office or gross misconduct, my lord. And the point that I want to hammer home probably is that not any other offense, my lord, will then qualify within those parameters, my lord. There was a deliberate use of the word gross in 2 of the grounds that have been set out under Article 181, which has then now been interpreted by the Honorable Court in the Wambora as well as the other petitions before you, my lord. My lord, in light of the guidance that you have given, I will then go into the issue of the public interest in line with the guidance you've given.
Yes.
We will hope that the court will be able to peruse the rest of the submissions as filed for lack of.
Yes. I already have.
Thank you, my lord. My lord, we then go into the question of whether it is in the public interest to allow the petition, my lord. My lord, the petitioner is the first governor, my lord, in the history of devolution since its inception, to face 5 charges, 5 impeachment attempts, my lord. We have been able to set out the various impeachment process that she has been able to go through in our affidavit.
Yes.
With the first one being, I think, 57 days after the inauguration, my lord. This impeachment came in at a time when the governor had not even set up her county executive, my lord.
Yes.
Which then means that she had not been given ample time or other sufficient time to be able to put out the governance structures so that she can be able to implement the manifesto that she had for the people of Meru, my lord.
Yes.
The repeated impeachment attempts, as outlined in the proceedings, my lord, we submit, have far-reaching implications, my lord, on the governance of the county government, my lord. My lord, the governors as well as other state officers come into office on the basis of universal suffrage, my lord. They are elected by a majority. It defeats public interest, my lord. For any state elected into office to be subjected to continued and repeated, as has been demonstrated by the petitioner through her counsel,
Yes.
impeachment attempts, my lord. What then is the public interest, my lord? That the county government is always in a mood, or rather a mode, of an impeachment or a removal of the elected leader from office. At what point does the governor duly elected then settle in to be able even to implement her policies, my lord?
Yes.
My lord, with the provisions of section 33(8, as has been highlighted, my lord, also similarly in our submissions, it then gives the latitude of the assembly to then reintroduce further impeachment attempts. And my lord, because I've had the benefit of the sight of the videos that were just about to be played, my lord,
Yes.
I am almost certain that if this impeachment process was not approved by the Senate, then probably we might be facing another impeachment process, my lord. The trajectory that has been demonstrated by the County Assembly of Meru, and this is the first, has then been that if the Senate does not confirm the charges, they then just go back and reintroduce the motion. We submit that then stabilizes the operations and the governance of the county, my lord.
Yes, so on public interest,
Yes.
aside from a finding that section 33 subsection 8 is unconstitutional, does the first interested party have any other view as to a possible remedy for what you have outlined under that law?
My lord, we submit that that section is the core of some of these issues, my lord. If you look at the removal processes of other state officers, my lord,
yes,
like for instance for members of parliament, they are able to enact. The benefit they have is that they are makers of laws, unlike the governor who is in the executive, my lord. They've been able to chart out the Elections Act, which has certain cushions, my lord, with regards to their removal by way of recall, my lord. It has timelines within which the recall cannot be undertaken. You have to undergo a whole court process, and as such, they have shielded and cushioned themselves from this recall procedure that is then laid out in court. Probably that's the reason why we've not had any member, both of the National Assembly or even the members of county assemblies, being recalled, because they have legislated on parameters that have cushioned them.
so about 1 minute.
My lord, just to wind up on this particular question, these state officers of the capacity of governors are elected for a specific period of time, my lord, to deliver service, my lord. If we then have a trajectory of an assembly going against to institute impeachment proceedings,
Yes.
within those timelines that we have seen the County Assembly of Meru institute, my lord,
Yes.
we will then have a scenario where there are constant interruptions to the governance. I have attended these proceedings, and the governor has been attending these proceedings since we commenced, even mentions.
Yes.
So our whole day is then spent in these corridors, my lord.
Yes.
Countless numbers of times are spent within the corridors of the Senate and the Assembly, my lord. At what point will the county then allow the governor to settle, to set up,
Yes.
and to implement, my lord?
Your
That
time,
is-
your
that-
time has expired, but I will repeat the question I posed to you.
Yes.
Other than a finding of unconstitutionality for section 33 subsection 8, what else could the High Court do? Because you have, under public interest,
Yes.
fleshed out a problem. You've argued it at quite some length, but your solution is only 33.8, which may not work.
My lord, the solution, just to clarify to the court,
Yes.
is probably what I commenced with. Despite Article 181, Sub-Article 2, laying out specifically of a need of a legislation to take care of issues of impeachment, we have not seen any such legislation. Perhaps, my lord, just to guide...
I have to say that for the record. What is the first interested party's proposal for the problem that it views?
The problem can be, because this is a governance issue, my lord, the problem can be through enactment of a legislation that then substantively defines these parameters, because this has been left to the various judgments. It will then lay out processes in great detail.
Yes.
It may also have regulations, my lord. And I just wish to end by saying that it is in the interest of justice and in public interest that we allow the petition as amended. I want to thank you for the time that you've given, Lord.
Thank you. Yes, ma'am.
Thank you, my lord. I think my name and details were taken for the record.
Yes, you miss Malas. You're quite well known as well.
Not aware, thank you very much. Right, I'm here on behalf of the Federation of Women Lawyers. The reason that we joined
Just a
this...
moment. I was right to you. Yes.
I'm here on behalf of the Federation of Women Lawyers, and we thank this court for enjoining FIDA to this matter, because one of the key components and assignments of FIDA since establishment in the 90s is to advocate for women's rights, and that means all women from all walks of life, shades, shape and sizes, including the governor for Meru County. So the work you're doing today, Honorable Judge, is a very serious assignment for the women of Kenya, all the well-meaning women of Kenya, including myself, because I have plans to be a governor not long from today. And my lord, that is why the impeachment of Governor Kwina Mwangaza must be quashed. This is because since 1963, that is 12 December 1963, what the people of Meru County Assembly have done to the governor has been the greatest affront to realization of women's political rights in Kenya. There has been none worse than that, my lord. Perhaps, and because I had counsel refer to Anarita Karimi, I would like to say that we can only compare what she's going through to what that lady Anarita Karimi went through. She was not only bundled out of parliament, but she was also jailed in a very discriminatory manner. And I wish to say that there are various similarities between these two women. one of which is that they are both from Meru community. So what I would like this court to do this afternoon is also to focus on this community of Ameru and how it is that they view women. Because since 1975, my lord, I see you thinking.
My lord, we object to assertion of incast against our community.
I don't think there's a safe way for me to record that at all. It may not do the proud Ameru community service for me to record that.
I will use a different way. I just want to say that both women were from the Meru society, and since 1975, when Anarita was elected, the second other elected woman from the community is Honorable Kwina Mwangaza to that level. There has been no other parliamentary elected woman in a contested all-gender election since 1975. Why am I saying this? It's because I don't believe it will be possible to give a fair, full and final determination of this matter without looking at the social and cultural aspects of the society.
Now, there's quite a lot of case law on the ambit of an interested party and what they can do. That submission strays quite far from what the petitioner has stated. In essence, it creates its own petition and then argues against it. There has been no allegation by the petitioner of gender discrimination.
My lord, I have to say that we are here in support of the amended petition filed in December last year.
Yes.
And when you look at
does not contain that gender discrimination aspect, an interested party then cannot create a substantive ground, because gender discrimination is prohibited by the Constitution. I could determine the petition on that ground and that ground alone. So an interested party cannot create.
So there's the aspect of equality under the law in the petition.
Yes.
And lack of there having been equality under the law with respect to.
So let's go to the amended petition dated 23rd December 2024. So one of the things that we do with petitions is we begin by stating, normally it's paragraph C, the constitutional foundations of the petition. So in paragraph 14, that is page 4 of the amended petition, the petitioner says Article 27 provides for equality and freedom from discrimination, and particularly that every person has a right to equal protection and equal benefit of the law. Further, the state shall not discriminate directly or indirectly against any person on any ground. However, when they go into the contraventions and violations, they argue that very, very differently from the route that the interested party appears to be going down. The equal protection argument there was substantiated in terms of a process, not substantive discrimination. Perhaps Councillor Ngoya or Councillor Chuma?
No,
this
my
point
lord,
you can,
sorry.
no, so that we just know, was there a gender discrimination, ethnicity discrimination angle?
Yes, my lord, if you look at volume number 1, that is the supporting affidavit of Kwina Mwangaza, sworn on 23rd December 2024.
Yes, there's paragraph 4 of the
paragraph
same.
4, yes.
Yes, paragraph 4 of the same.
Yes.
I'm not disputing that there's a paragraph 4 of the same in the supporting affidavit. I am in the petition stage, and I hope now we can all agree I've read all your documents, and I know them backwards and forwards. What I'm asking is, in the petition, because you cannot also create a substantive ground of disclosure. In the petition, as what is said at paragraphs 4, 5, 6, 7, 8, and then a little bit on 9, is that stated in the petition, in the amended petition, in terms of the region, the relentless ganging up, in terms of gender or ethnicity? Just that.
Let me just say this and bring it to the court. One,
Yes.
the petitioner has pleaded discrimination. Number two, the petitioner has made reference to her gender at paragraph 4 as we alluded to it. And number 5, when the second interested party filed made a request to join here, they disclosed what the scope of their identifiable stake in the matter is, and was that gender dimension. I will leave it to the court to see how to guide them from that onward, but I guess that when my learned colleague, Ms. Lumalas, came to the matter, she made it clear from the very outset that this is her stake in this matter.
Councillor Lumalas, your time has been off. I've expressed my reservations, but I will allow you to proceed with that argument.
Thank you very much.
Yes.
Actually, when you look at our application for joinder, notice of motion, this very issue is what was the main reason why we joined. And the limb of her political rights and violation and discrimination.
Yes.
When you look at the petition, they have pleaded Article 38.
Yes.
And I'd like to refer this court to Article 38, 3C of the Constitution.
Yes.
So that when Honorable Kawira went on election and won the election,
Yes.
she has a duty to enjoy that seat, or a right to enjoy that seat. And you as the court, my lord, you come in at Article 38, 3C.
Yes.
That since she has a right to be a candidate for public office, to belong to any political party of her choice, then according to this article, she has a right not only to be elected but to hold that office.
Yes.
Yes. Now what we are saying is that there's been a deliberate scheme to ensure that she does not hold that office. We thank God that irrespective, because our submission is that that community is a very patriarchal community. We submit that. It is our submission based on evidence on record. We also wish to
just a moment, Council. If you have an issue with anything that Council has said in submissions, please don't articulate it too loud. I'm not saying you can't articulate it, but not too loud. Yes, Council?
Thank you very much. I've been interrupted a lot, my lord. But that shows you that I am on to something. Because in the morning there was the question of, because my lord, I've talked about 5 impeachment motions. And look at the dates of the impeachment motions. Barely 2 months after she was in office, November 2022, the first impeachment motion. Second impeachment motion, same year of election, 30th December 2022.
Let me have the first date, please.
21st November 2022. 30th December 2022. This is election year. 17th October 2023. 17th July 2024 and 31st July 2024. My lord, in the morning when the question of what the Meru court meant by saying, using the word that there's a possibility of some gamers behind this scheme, I had an opportunity to review the videos before I came to court, and I would like to refer the court to some of the video recordings which will support our position. KMV 12, KMV 15, KMV 17, and 11. My Lord, when you look at these videos, you will understand, and you are there on the online platform when you are requesting to join as interested parties. You saw the level of abuse.
Yeah.
And it is typical of a patriarchal society to get a woman to fight another woman, my Lord. This morning we saw one lady by the name Zipporah, who is a 6th interested party, who, having no faith in her counsel, wanted to stand up and address you. And I'll tell you why. The reason is when you look at volume 1 of the petition, volume 1, is your volume 1?
Your Lordship, I will request that counsel provides evidence that my client has not found.
Counsel.
But the evidence was...
Just a moment. Counsel. You know, we don't need to make everything
That's all.
it's not an issue. What you can perhaps consider is the court has already said it has reservations. That is already very, very simple. But I have said I will record, but I have said there are reservations how this is being taken. Yes, Counsel, please proceed.
As I wound up, I just want to let the court look at volume 1A.
Sorry, you left me at a patriarchal society,
The men,
a woman,
yes, to fight another and hurt another woman. And one such woman stood here this morning. Her name is Zipporah Kenya. She's interested party, 6th interested party. And unfortunately, this happens a lot among the women folk. But you can see she wants to take the glory out of...
No, that is not.
I'm actually referring, my Lord, I'm referring to her own words.
Yes.
When you look
I
at...
understand that is what was stated in the 6th interested parties affidavit. The challenge is if you were to reference that specific argument within your written submissions, what paragraph would I be able to look at?
My Lord, I'll proceed.
It's a big challenge you've been having, and
it's okay.
I recognize.
You know,
I recognize what you were saying earlier,
yeah.
and perhaps there is need for us to do these sorts of cases differently. Perhaps we should have the hearings. We should have a standalone hearing,
yes,
and then
submissions.
Of written submissions. I will.
Thank you. I only just brought it up because of an interruption of the court session, but then I'll leave it to the court. Now, so having moving to conclusion, so the impeachment of Honorable Kawira was not lawful at all. When you look at the process in Parliament, you see the need to rush the proceedings. Not only in the manner in which the gazettement happened, but also for me personally, and this is what we've taken out in our submissions. Having known parliamentary proceedings, I have 8 years in parliamentary work, there was no need not to give the senators a right to submit. And their complaint is on record, and that is one of the issues we have pleaded. There's always an opportunity to let the hearing proceed to the next day. That is one. Number two, Honorable Kawira, and we all saw that, was not given an opportunity. I don't know if you're recording this.
Yes, I am.
She was not actually given an opportunity to respond after a barrage of submissions by a section of senators. When she asked for an opportunity to respond, the speaker informed her that time is up. So whose time is up? And are those considerations for fair hearing, my Lord? When you look at the Constitution and what it guarantees with respect to a fair hearing, you will find that that kind of hearing is devoid of chaos. Just for the chaos which have been admitted in the Hansard alone and the violence, that impeachment has to be voided. And the fact that she was not given an opportunity to respond in oral submissions, that is also a violation of due process to be had. It has to be quashed. So what are we asking? We are asking you to review and give appropriate orders that will enable women in political offices, irrespective of the environment that they operate in. And we have demonstrated that both Kwina Mwangaza and Anarita before her operate in a very patriarchal, male-dominated environment. And I have an article on patriarchy, which unfortunately I didn't share, but I'm happy to distribute. That community is still heavily dominated by the decisions of the Njurincheke. And they have already declared who their spokesperson is. They have installed the deputy governor as a leader. That's all in the videos. I saw that, my lord. And I hope you will see that and the implication of this. So that when you're issuing the orders, you will declare, as we have requested in our submissions, that...
I wish to object to what Council just said. It is misleading. And there is a video in the videos that were submitted of the deputy governor being installed in the gas. It is not on the
I will qualify it this way. It's not installed, but oathed.
Just a moment. I was constrained when Councillor Ongoya raised this point, but now I will have to formally say this. The objections, aside from one, were not of the nature of objections. Councillor Ongoya said it is a scheme to deliberately take those in support of the petition off their train of thought. And I didn't say anything, because that's a very high threshold that you guys have. But it has been. It has been. Not everything needs to be an objection. It's a statement that has been made in the written submissions. I have already expressed I have reservations as to whether there's a nexus between the amended petition and those submissions, but I've had enough to continue recording. So let me state this plainly. The next time anyone in opposition of the petition rises, it should be a cogent objection on law. Not an argument that this is not relevant, that you will have in your time. Am I understood?
Yes, I just wish to really plead with this court to declare Section 33(8) of the County Governments Act unconstitutional, as already pleaded, to issue an injunction against further discrimination and public abuse and ridicule of Honorable Mwangaza, which is why we are also here, because there was a lot of abuse online. And we would like that, once these orders are out, that the people of Meru are managed and they accept their governor until the 5 years are over. I thank you, my lord, and we look forward to upholding of the rule of law in this matter. Thank you.
Thank you. So for the avoidance of doubt, everything that has been submitted by counsel for the second interested party has been recorded. It is safe and it shall be considered in the judgment and to be treated in the same manner as the other submissions. Seventh interested party.
Much obliged. Thank you.
Thank you, my lord.
You promised me 6 minutes.
Yes, I promised you 6 minutes, and I try my best to live to that. My lord, I represent the National Gender and Equality Commission.
Yes.
And the commission comes in support of the petition. And before I proceed, I would like to state for the record, I'm a he for she. Thank you, my lord. I'm a he for she. I'm a he for she. I'm a champion for gender rights. Thank you, my lord. My lord, allow me to go straight to the ground as to whether the impeachment proceedings violated the petitioner's rights of equal protection and benefit of the law. Without going much into the details, because the petitioner alluded to this. My lord, what is the law?
Just a moment, yes.
on a point of law, as you have correctly guided us.
Yes.
The 7 interested parties council states that he rises to support the petition.
Yes.
And in doing so, my lord, he has filed before this honorable court
Yes.
a replying affidavit in support of that petition,
Yes.
sworn by a person by the name Weru Kiri.
Yes.
My lord, we seek to draw to your attention that the said affidavit is sworn on 15th of January 2025
Yes.
and commissioned by one Anne Rasolo,
Yes.
an advocate of P105.
One and
Anne Rasolo, R-A-S-O-W-O.
so just say the name again.
Anne Rasolo,
Yes.
R-A-S-O-W-O.
Yes. Yes. So
Our number is P105.
yes.
Stroke 10007
Yes.
stroke 13.
Yes.
My lord, the said Anne works at the National Gender and Equality Commission, and therefore the affidavit that she has filed before the court, as you have just discovered,
Yes.
is incurably defective, and it must be struck out of the record of this honorable court. In addition, my lord, we know that the said Anne Rasolo, despite commissioning the said affidavit and being an employee of National Gender and Equality Commission, and having commissioned the said affidavit this year, she does not have a practicing certificate. My lord, those two issues go to the root of the affidavit and the case that the 7 interested party tries to make before the honorable court, in the sense that the affidavit violates section 4(1) and 2 of the Oaths and Statutory Declarations Act and section 24(2) of the Advocates Act. It follows therefore that the submissions that council wants to make before this honorable court have no basis. The 7 interested parties has no legs to stand on, my lord. It must fall flat on its face.
Yes. Yes, you can have a rejoinder.
Thank you, my lord.
Response.
The commissioner, Anne Rasolo, is a commissioner for oaths. As of 15th January, she was an active legal practitioner with a valid practicing certificate. It is anything into question of a practicing certificate can only be questioned after 31st of January 2025. Thank you, my lord.
Rejoinder.
My lord, section 24(2) of the Advocates Act states that a practicing certificate is valid from 1st of January to 31st of December. The only time that the practicing certificate is valid for the next first month of the year is when that advocate has made an application to renew that PC. The PC, my lord, as we are looking right now, is still inactive. It means she has not renewed her PC.
Yes.
And my lord, we understand that the court is tech savvy. It's a decision that the court can easily make by checking the advocate's search engine to establish whether the said Anne Rasolo is active or not.
Just a moment.
It will also demonstrate, my lord, where that part of the man works.
You know, without making a new line of argument, is counsel saying that this advocate was not licensed to practice for the year 2024? I don't hear him to be saying that. He's saying as at 15th January 2025, this advocate was not licensed. Is there any one of us who had our license out as at 15th of January 2025? I'm posing a question in my Lord. I can't respond it like that. My colleagues know that their clients can do that and they would understand. But for them to do that, even they know they're out of order. They can't do that. Isn't there sufficient practice that this court can take judicial notice of, that every advocate in this country is allowed to practice up to and including the end of January of the succeeding year for the renewal of the license? So I think that's a matter that we ought not to make a big issue when we concede that this advocate was licensed in 2024, which I can see clearly on the portal that she was licensed.
There are two arguments that have been made. I'll deal with the second one. Even when I had to take out a PC, it would take some time. And it wasn't always, even in our law firm, there were multiple advocates. Some of us would be active before the rest. And we paid under the same check at the same time. So that is not determinative of the probity and admissibility of the impugned replying affidavit. The other link, the first link, the question of whether an advocate of the High Court internal to an organization can commission a affidavit is the more cogent and persuasive one. Is it in dispute that the Commissioner for Oaths works within the seventh interested party?
My Lord, it is not in dispute.
Who has a hard copy of it? What counsel should have also pointed out, which I have confirmed, is the Commissioner for Oaths address is the same, postal address is the same address as that of the seventh interested party. There's a reason that even when we're in our law firms, we have to walk outside and ask a colleague to come over, or we take the deponents to their chambers for them to commission. We are not allowed to commission internally, so that aspect is sustained. Now the challenge will be, have you filed written submissions? I need to state it for the record.
Yes, my Lord, we have filed written submission.
If you lose your replying affidavit, then you will lose your written submissions as well, because your written submissions went deep into what has been deponed to, particularly tying a nexus with paragraph, tying a nexus with paragraph 4 and 5 of the petitioner's supporting affidavit. So, quote, an objection has been raised to the seventh interested parties replying affidavit dated 15th January 2025 on the principal ground that it was commissioned by an advocate in the employ of the seventh interested party, thus in contravention of the oaths and statutory declarations act. Counsel for the seventh interested party has conceded that this is factually correct in terms employment. Thus, find that impugned underlying affidavit is improperly commissioned, thus is fatally and incurably effective. Today being highlighting of written submissions, the court had already preliminarily perused and considered the respective parties' written submissions. In that regard, I note that the averments of the now struck out decline affidavit filed by the 7th IP permeates the entire length and breadth of their written submissions. Consequently, the 7th IP's written submissions are equally fatally defective and cannot be relied upon as the substratum does not exist. The 7th interested parties submissions thus also struck out. However, in the interest of justice and noting that the 7th interested party has participated diligently in these proceedings, they shall be allowed 5 minutes to submit, but limited to the petitioners, first IP, first interested party, and second interested parties written submissions, 21st February 2025. So I will limit you only to those 3 parties, 5 minutes, please.
Thank you, my lord. Now, in terms of whether the petitioner's right to equal protection and equal protection and benefit of the law was violated, my lord, we proceed to ask this question: what is the law, or what was the law in the context of these impeachment proceedings? From a legislative perspective, the law are, from a legislative perspective, the laws are acts of parliament, statutes, but from a judicial perspective, the law is or includes rules of court, court orders, and perhaps to mention in Article 23 includes all those reliefs. Once granted, they become the law, or once issued. In this particular impeachment proceedings, my lord,
yes,
at the county assembly, there was a conservatory order, a law that had been issued in favor of the petitioner.
yes,
The violation of that law put the petitioner in an equal status where she could enjoy the protection of the law that she was seeking. On the other side of the parallel,
Yes.
put the fifth interested party in a position where it was able to proceed with procedural laws to impeach the petitioner, thereby violating that right of equal protection and benefit of the law.
Yes.
At the Senate level, that particular violation was brought to the attention of the Senate.
Yes.
Its lack of consideration, again, we submit, then put the petitioner in a position where she was denied the right to benefit and equal protection of the law.
Yes.
My Lord, I go to the second limb as to whether the public participation met the constitutional threshold.
Yes.
From this perspective, we wish to submit from the perspective that, one,
Yes.
The Assembly's public participation analysis report, from page 1 to the last page, does not, one, show as to whether the participants were read out to the grounds upon which the proposed impeachment proceedings were supposed to proceed on. Two, as to whether the evidence that was in support of those impeachment grounds was laid out before the participants.
Yes.
And number three, as to whether they appreciated the impact. And therefore, as a whole, we submit, because of that failure, the public participation did not meet the constitutional threshold under Article 10 and as laid out by the Supreme Court in the tobacco case. Number two,
that's BAT?
BAT case, yes, sorry.
Yes.
Number two is that the public participation failed to appreciate the uniqueness of the circumstances under which the governor came into office.
Yes.
Which is, and I ask this court to take judicial notice of the fact that Kenya as a whole is a patriarchal society. Number two, that the petitioner came into office through the secret of the ballot that allowed the people of Meru to be able to exercise a decision to elect a candidate on an independent ticket against a highly patriarchal society on the one hand, and number two, a highly political party-based society that is male-dominated.
Yes.
And therefore, the public participation, in its failure to ask itself on how it would allow the members of Meru County who voted for the governor to be able to express their will.
Let me catch up with you speaking, and then you'll have 2 minutes. Yes. Proceed.
And therefore, the failure of the public participation to take into account the uniqueness circumstances under which the people of Meru emancipated themselves from a patriarchal nature of society through a secret ballot to vote into place a female governor, how they would express their wishes either for or against that impeachment proceedings in an open society or in an open manner where those public participations were taking place. The written submissions do not give, or the written analysis of the written memorandums does not give an indication as to whether that was given or taken into consideration. And finally, my Lord, on the question of whether the governor is targeted or all the impeachment proceedings are targeted against her because of her gender, we submit that number one, she's the first elected governor in Meru, women governor. The leadership of Meru County has no other, save for women's representative seats, has no other female elected member of parliament. At the county assembly, we only have 4 elected members of county assembly as of the 2022 general elections. What? Sorry, 1. 4 is in the previous 2017 general election, 4 members. So So the totality of this, my lord,
Yes.
that I'm putting across is that when you take time to look at those videos that you said, I hope you get an opportunity to look at KMV6. KMV6.
Yeah.
Where you will see an oathing ceremony of the Churincheke taking into place. Churincheke, that is a male-dominated customary leadership organization in Meru,
Yes.
does not allow women to speak or address it. And number two, where the political leaders who form the biggest formation within the County Assembly of Meru, led by the UDA and the political party known as BAS, were sworn to declare their support for the impeachment motion without consideration as to whether the grounds of impeachment had been qualified. And therefore, on that basis, we submit, my lord, that the impeachment proceedings, right from the first impeachment proceedings, have been targeted on the governor because of her gender and victory over the patriarchal nature of the society in that county, and perpetuated by male political leaders as well as influencers in Meru County, to the disadvantage and violation of the petitioners' both political rights and procedural rights as regards these particular impeachment proceedings. We submit.
Thank you, Council. So that is the conclusion of highlighting of written submissions for those in support. We will reconvene on Monday, and the session shall be as follows: from 12 noon sharp to 3 p.m. Then we'll take a 30-minute break. Please carry packed lunch so you don't need to leave the premises. Then we'll go from 3:30 until whatever time we conclude. But I hope we'll be able to do 12 to 3 for those opposed. If there's a little bit of spillover, that is understandable. And then a rejoinder limited to only the petitioner for about an hour. Thank you, all of you, particularly Council, various Council. I think today's session is a very good example of the benefit of highlighting of written submissions, and there are two very good examples of where an objection is raised and it is sustained. I really do enjoy hearing highlights in matters like this. So I look forward to seeing you all on Monday. Have a good weekend.
What's your name again, my name? My name is
Thank you. See you then.